Good afternoon! Szeretettel üdvözlök mindenkit, aki a délutáni órákban is velünk tart. A harmadik szekció előadásait fogjuk meghallgatni, de mielőtt erre sor kerül, engedjék meg, hogy néhány technikai jellegű információt megosszak önökkel, főként azoknak számba ezeket, akik még most csatlakoztak hozzánk, hiszen a délelőtti szekcióban irányadó szabályok most sem változnak. A kérdések feltételére bátorítjuk a hallgatóságot, szeretnénk, hogyha nem maradnának tisztázatlan kérdések. Úgy tudnak az előadókhoz fordulni, akár kérdéssel, megjegyzéssel, kiegészítéssel, hogyha ezt a chat funkcióba beírják. Az előadás után fog sor kerülni a válaszokra, és külön kérem önöket, hogy az első előadónknak, Robert Kett professzor úrnak címzett kérdéseiket feltétlenül most tegyék fel, mert legjobb tudomásom szerint ő nem tud végigmaradni ebben a szekcióban, tehát a délelőtt folyamán megszokott együtt majd a végén teszünk fel kérdéseket, megoldás itt nem fog működni, hogyha Robert Kett professzor úrhoz van kérdésük. A másik szintén már ismert megoldás, hogy a tolmács funkciót azt a képernyő alján találják meg, és itt kell állítani a nyelven, itt kell beállítani azt a nyelvet, amin szeretnék hallgatni az előadásokat. Egyben kérem az előadókat, hogy ők ne válasszanak nyelvet, hanem az off funkciót állítsák be a tolmácsokra vonatkozó jelnél. A jelenléti évet ismételten ki fogja küldeni a kolléga, akik még nem töltötték ki, azoktól kérjük, hogy ezt legyenek szívesek megtenni. Ami újdonság, hogy egy értékelő kérdőív is kiküldésre kerül majd. Arra kérem önöket nagy tisztelettel, hogy szánjanak erre időt, és hogyha tudják segíteni a munkánkat azzal, hogy a konferencia minőségét, a rendezvény egészét értékelik, akkor ezt nagyon kérjük, hogy tegyék meg. A következőkben, és itt még elnézést csak rápillantok egy rövid időre arra, hogy mit kell még elmondanom. Igen, az előadóknak ebben a szekcióban már egy kicsit rövidebb idő áll rendelkezésre. A délelőtti szekciókban 25 percig beszélhettek, most 20 perces előadásokat fogunk meghallgatni, és ugyanúgy a 3 perccel az idő letelte előtt jelezni fogjuk, hogy már nagyon rövid idő van hátra, és az idő leteltével, a 20 perc leteltével ugyanígy fogunk jelzést adni, hogy sajnos letelt az idő, be kell fejezni az előadást. Arra kérek minden kedves előadónkat, hogy legyenek tekintettel arra, hogy a konferencia munkáját tolmácsok segítik. Olyan ütemben, olyan gyorsasággal beszéljenek, hogy a tolmácsok tudják fordítani, és olyan hangosan is, hogy az érthető legyen. Azt hiszem, hogy ezzel minden technikai jellegű információt elmondtam, ami a tartalmat illeti. A délutáni szekciókban is nagyon érdekes előadásokra kerül sor. Néhány előadás kapcsolódik a délelőtt elmondottakhoz, annak mint egy folytatásaként is jelenik meg, de lesznek, amik újdonságot jelentenek. Az első előadónk Robert Kett professzor úr, a Bécsi Közgazdaságtudományi Egyetem tanszékvezetője, akinek az előadása a belső, külső, büntető és szabálysértési nyomozás sajátosságaival fog megismertetni minket, és arról fog még szólni, hogy milyen az különböző eljárások között az átjárhatóság az osztrák jogban. Ezen túl természetesen majd szó lesz, én abban a szerencsés helyzetben vagyok, hogy az írásos verziót már láttam, Szó lesz ezeknek az eljárásoknak az elhúzódásáról, az időigényességéről is, ami különösen nagy problémát jelent, vélhetően nem csak az osztrák jogban. Robert Kerr professzor úr, öné a szó.
So, thank you very much. I hope you see now my pictures and my presentation. Thank you. Thank you. Thank you for the invitation to participate in this project again after this very successful project 2 years ago. Sorry that I'm not able to join the whole conference today because I have some classes, but I will come back later again. As I agreed with the organizers, I want to give a short overview on the Austrian investigation in criminal matters. We'll show some current problems and will present some aspects of the use of evidence in criminal procedure. First of all, it is an important feature of the Austrian fraud prosecution system that there is a structural duality between expenditures and receipts of a state or of the EU, which also has consequences for the prosecution and for investigations in cases of offenses which affect the financial interests of the EU. Fraud which relates to state or EU expenditures is governed by the criminal code, and fraud related to receipts of a state or the EU is governed by the Act on Fiscal Offenses. What does this mean for investigations? Regarding expenditures, the investigations follow the provisions in the Code of Criminal Procedure. Regarding taxes and customs, in principle, also the Code of Criminal Procedure is applied. However, in the Act on Fiscal Offenses, specific provisions are provided for which differ in some aspects from the general provisions in the Code of Criminal Procedure. In fiscal penal law, the competence for leading the procedure, investigating, adjudicating, and sanctioning is divided between administrative authorities and criminal courts, depending on the amount of the evaded taxes. It is divided into an administrative fiscal penal procedure for minor cases and a judicial criminal procedure for major cases. A central role in investigations in fiscal penal cases is played by a specific authority, an administrative authority, the so-called Fiscal Offense Prosecution Authority. In minor cases where the damage of a tax evasion is not more than 100,000 euro, it is the task of this authority to investigate, prosecute, and adjudicate. In other cases, it's more complicated, and this authority plays a special role in criminal investigations. I will come back to this later. The main players in criminal investigations following the Code of Criminal Procedure are the Public Prosecution Office and the Criminal Police. The Public Prosecution Office is head of the investigation proceeding and decides about the continuation and the end of the investigations. Most of the investigative measures must be ordered by the public prosecutor and they are carried out by the police. Only in cases of investigative measures which interfere with fundamental rights of the accused or of a third person, for example, pretrial detention, house search, telephone tapping, the order of the public prosecutor needs to be approved by a judge. In reality, at the beginning of investigations, mostly the police investigates on its own and only in complicated and difficult cases, as, for example, economic criminal cases, the public prosecutors investigate on their own. In most cases, the police investigates the cases. There is a specialized central public prosecution service for the prosecution of economic crimes and corruption cases, which is seated in Vienna, but is competent for all for the whole territory of Austria, and it is competent for severe cases of economic and fiscal penal crimes, which with a damage of more than 5 million euro, and in cases of corruption. During the investigation, the court has only the competence to approve certain coercive measures, has to decide on applications for the imposition of a pretrial detention, but only in exceptional cases, like investigations against prominent politicians. Only in these cases, the investigations are led by the court itself. Finally, the court is competent to decide on remedies of concerned people who claim that they were violated in their personal rights by investigations by the Public Prosecution Service, since they it was refused to exercise their personal rights, or the provisions of the Code of Criminal Procedure were violated. In tax and customs crimes, the investigations are not led by the police, but they are led by tax and customs investigations authorities, and I have already mentioned it. There is the Fiscal Offense Prosecution Authority, the Finanzstrafbehörde, which is competent for the clarification and prosecution in duty of the criminal prosecution. This authority has to perform the task and has got the powers of the criminal police and has to perform this task instead of the criminal police. It has to apply the provisions of the Code of Criminal Procedure, which is a standard basis for the investigation proceeding. Therefore, in principle, there are no specialized, no specific procedural rules for financial criminal investigations. However, there are some specific powers for the fiscal offense prosecution authorities, which are laid down in the Act on Fiscal Offenses, for example, inspections and examinations according to the tax and monopoly provisions, or the right to obtain information from providers of public telecommunication services that's differently or different to the rules in the Code of Criminal Procedure. The Public Prosecution Service also conducts and supervises investigations in fiscal criminal offense cases. It was already mentioned that I want just mention one major problem of investigations in economic criminal cases in Austria, and this is the duration of investigations in economic criminal cases. Investigations in some big economic criminal cases last for more than 8 or 10 years. We now had a big corruption case where the facts took place in 2002. Investigations took more than 9 years, the main proceeding more than 3 years, and we still have no final decision nearly 20 years after the behavior was set. What are the reasons for that? The Austrian criminal procedure is characterized by the principle of material truth. This means the law enforcement agencies are obliged to investigate all details of a case, even if they are not relevant for the application of the criminal offense, or does only concern minor aspects of the case. This principle perfectly fits to common criminal offenses like theft or bodily injuries, but it's complicated in cases of economic criminal proceedings and results in very long and complicated investigations, since the facts are so complex and it is nearly impossible to investigate all problems. However, it is difficult under the current legal provisions to focus and limit investigations in certain on certain and the most important facts. There are no possibilities of agreements in criminal procedure, at least no official possibilities. The Austrian Supreme Court said that judges commit an abuse of official authority to take part, if they take part in any agreements. Another reason is that in economic criminal proceedings, often a large quantity of documents and especially storage media with electronic data are freezed, and the criminal police or the public prosecution office have not checked the relevance of these documents and data for the proceeding due to the extent and the complexity of the proceeding. The freezing of these documents and storage media for evidence reasons is only justified by the necessity to check the content of these documents and data, and it takes many months, sometimes even years, to check the relevance of these documents or this data for the investigation and for the concrete case. Often specific expertise is required. It is necessary to appoint an expert, and this leads often to further delay, especially if the expert has not yet been involved in this proceeding and therefore does not know the case in detail. Let me come to the question of use of evidence in criminal proceedings. The Austrian legislation in principle enabled to use all evidence collected if there is no explicit prohibition to use the evidence. Such an explicit prohibition exists, for example, for certain investigative measures, for example, for telephone tapping or visual surveillance, but there are many investigative measures where we do not have such explicit prohibitions. If an evidence is illegally collected, this does not mean that all other evidence which has been found because of this evidence cannot be used. In fact, it must always be examined for every evidence whether it is usable or unusable. If the law explicitly says that the collecting of a certain evidence or a certain investigation measure is void, this means that it cannot be used or is not allowed to be used in trial. However, in most of the cases, evidence can be used even if certain rules of evidence were violated. For example, if the rules for a house search were violated, the results of this house search can be used. The Supreme Court explicitly ruled that evidence can be used, and it said that these objects and data have not to be given back to the owner, and that it is not necessary to destroy this evidence, since this is not explicitly foreseen by law. A violation of prohibitions on the collection of evidence does not have automatically the consequence that the evidence may not be used in the main proceeding or in the investigation proceeding. However, the Supreme Court limited the use of such evidence insofar as it must not be taken into account as reason for the decision to commit the case to trial or for the arrest or pre-trial detention of the accused. This means the Supreme Court does not limit the use in general, but the possibilities to take them into account in investigation proceedings. Regarding the use of evidence gained in an administrative proceeding, there are no rules which prohibit the use of such evidence in criminal proceedings. Such evidence, for example, documents may be introduced into the trial, and it is up to the court to evaluate this evidence in free assessment of evidence. The rules for interrogations laid down in the Code of Criminal Procedure are not applied to interrogations by other authorities in administrative proceedings, and it is no problem to use the results of this interrogation in a criminal proceeding, even if the rules of the Code of Criminal Procedure have not been observed. For example, in administrative proceedings, it is not necessary to inform the concerned person about the right to remain silent if there is a risk of self-incrimination. Nevertheless, the results of this interrogation can be used in the criminal proceeding. Therefore, in general, it can be stated that the use of evidence gained in administrative proceedings is not excluded in criminal proceedings. However, in the doctrine, it is said there should be limits to take over evidence from tax and duty proceedings, for example, if they do not comply with the principles of criminal proceedings, especially with Article 6 of the European Convention on Human Rights. Regarding internal investigations, we have already heard a lot from Professor Sawyer this morning. Therefore, I just want to add shortly that there is no law in Austria which rules internal investigations, and there is also no law about the use of evidence collected in internal investigations. Therefore, in principle, it is allowed to use evidence evidence which has been collected in such investigations, the use of such evidence does not make the trial unfair. It's the same reason why it is quite easy to use also evidence collected in other member states. The bigger problem is to get this evidence. That is not only a problem with countries outside of the EU, but also with other EU countries. Prosecutors often say it's easy if they can have a direct contact with prosecutors in other member states, but it becomes difficult if it is only on an official way. They use the European Judicial Network, they use Eurojust, but whether the contact with authorities of other member states is successful in many cases depends on the effort made by the individual investigator or prosecutor in the other member state. Let me come to an end and to a last point, because it's very current. 5 days ago, the law to implement the EPO regulation was passed by the Austrian parliament, quite late, but they did it. It provides that Austrian law concerning the tasks and function of public prosecution, of the public prosecution service, also applies to the EPO, as far as this is not in conflict with European law. The EPO is competent for the investigation, prosecution, and committing the case to trial in PIF cases, and has the same position as the Austrian Public Prosecution Service. According to Article 13 of the EPO regulation, the European delegated prosecutors shall have the same powers as national prosecutors in respect of investigations, prosecutions, and bringing cases to trial. It is ruled by this new Austrian law that the European delegated prosecutor has to proceed according to the provisions of the Code of Criminal Procedure, and in particular, he has to observe all conditions and requirements for investigations and taking of evidence. Let me come to a short conclusion. One of the main problems of investigations in economic criminal cases is the long-lasting investigation proceeding. It seems that the current legislation makes it difficult to speed up such proceedings, since all cases must be investigated into details. This takes a lot of time, requires a lot of patience for the accused and also for the authorities. The use of evidence is mostly admissible in Austria, since there are only a few explicit prohibitions to use evidence in Austria. Therefore, also evidence collected in administrative proceedings, in internal investigations and other states is possible in the most cases. The bigger problem seems to be how to receive evidence from other states. However, in PIF cases, this should and could be improved when the EPO takes over the investigations in these cases. Thank you for your attention.
Thank you, Professor Kert. And as I can see, there is no question in the chat box. Esetleg akinek van kérdése, ahogy korábban mondtam, az most kellene, hogy feltegye, hiszen professzor úr nem tudja velünk tölteni az egész szekció időtartamát. Úgy látom, hogy nincs kérdés.
Otherwise,
Sorry, please.
If there are questions, I'm back at 5 o'clock and I can answer questions.
Thank you, you are very kind. Thank you. Thank you so
You're
much.
welcome.
Szóval, ha nincsen kérdés, akkor át is térnénk a szekció második előadására. Mindig érdekes számunkra, mint jogászok számára, hogyha egy általunk joginak vélt problémáról nem jogászok is véleményt nyilvánítanak. Így fog ez történni a következőkben is, hiszen Siklós Márta, aki a Corvinus Egyetem címzetes egyetemi docense, könyvvizsgáló, okleveles adószakértő, Leitner & Leitner partner budapesti kirendeltségének, minek lehet ezt mondani, a munkatársa, fogja megosztani a gondolatait a vállalati compliance szerepéről a belső vizsgálatokban. Siklós Márta a jogászitól kicsit eltérő szemléletmódjával már az előző Hercule projektünket is gazdagította, és nagyon örülünk, hogy ezúttal is velünk tart. Én át is adnám a szót, megkérném Siklós Mártát arra, hogy tartsa meg az előadásán.
Kedves professzorasszony, tisztelt résztvevők! Nagyon szépen köszönöm a lehetőséget, és őszintén remélem, hogy a hangminőség rendben van. Innentől kezdve, köszönöm a visszajelzést, én megpróbálom megosztani a fóliákat is, és remélem, hogy ez is sikerült. Látják a fóliáimat, hogyha most kérdezhetem?
Igen, látható, igen.
Nagyszerű, nagyon szépen köszönöm ezt a visszajelzést is. Hát, ahogy professzor asszony említette, én nagy valószínűséggel egy más megközelítést fogok adni ehhez a mai konferenciához, már csak azért is, mert igazából mi ugye könyvvizsgálóként és adótanácsadóként másképpen látjuk a dolgot, de hogy a cégnek az érintettségéről még egy kicsit beszéljek, azért azt el kellene mondanom, hogy hogyan is kerülünk mi ide. Hát úgy, hogy a cégnek az egyik névadója, Roman Leitner úr, ő a Finanzstrafrechtnek, azaz a pénzügyi büntetőjognak egy Ausztriában, és azt hiszem, hogy nem túlzok, ha azt mondom, hogy nemzetközileg is elismert szakértője. És akkor még a szakmánk érintettsége, ami szintén nagyon fontos ebben a témában, ez pedig ugye bennünket, mint tanácsadókat, és bennünket, mint könyvvizsgálókat, ugyanúgy a pénzmosás elleni törvény is kötelez, ugyanúgy a BEPS is kötelez, ugyanúgy a DAC 6 is kötelez, tehát vannak ilyenfajta kötelezettségeink, és azt kell, hogy mondjam, hogy kapcsolódási pontjaink is. És akkor nézzük, hogy tulajdonképpen mit is értünk mi ezen a compliance tevékenységen, és hogyan tudunk ezzel segíteni akár külső, akár belső felderítési, ha úgy tetszik, nyomozati tevékenységeket. Alapvetően, ha azt gondoljuk, vagy úgy gondolunk egy vállalkozásra, mint egy élő szervezet, akkor az élő szervezetben is időnként vannak olyan sejtek, amelyek megbetegedhetnek. Ezek egy vállalat esetében lehetnek személyek, folyamatok, amelyek nem megfelelően működnek. A compliance feladata ezeknek a nem megfelelő működéseknek a kiszűrése, vagy a megelőzése. Milyen módszerekkel éri ezt el? A folyamatok átvilágításával, detektálásával, és abban az esetben, hogyha egy ilyen nem megfelelő működést észlel, akkor értelemszerűen akár a hatóságok bevonása is célja lehet azért, hogy a vállalat maga életben maradjon. Ezt talán úgy lehetne összefoglalni, hogy to conduct the right businesses in the right way. Nézzük, hogy a compliance-nek milyen alapvetései vannak. A compliance alapvetően ugye egy jogszabályi működésnek való megfelelést tűz ki célul. Alapvetően ez a feladata, ennek kell mindenképpen megfelelni. Tág értelemben ez egy inherens, a vállalat működésébe épített, olyan önálló rendszer, itt hangsúlyoznám az önálló rendszert, tehát egy független rendszer, amely biztosítja a jogszabályoknak megfelelő vállalati eljárást valamennyi alkalmazott és vezető vonatkozásában. A compliance-nek nem célja az, hogy nyomozati tevékenységet végezzen, csupán a compliance rendszer felállítása és ennek a rendszernek a működtetése a célja. Hogyan is működik ez a rendszer? Oktatással, képzéssel, ezeknek a dokumentálásával, az eltérő hibás működés esetén az a cél, hogy bizonyítani lehessen, hogy itt egyedi, elszigetelt esetről van szó, azaz megtalál egy olyan személyt, aki személyében is felelős azért a nem megfelelő működésért, és bizonyítékokkal alátámasztva tudja azt igazolni, hogy nem a vállalat egésze az, amelyik nem megfelelően működik, nem a törvényi megfelelőség szempontjai szerint végzi a tevékenységét, hanem kizárólag elszigetelt, adott személynek a nem megfelelő működéséről van szó. Miért fontos ez? Azért nagyon fontos, mert a vállalat ebben az esetben megtarthatja azt a képet magáról, hogy a vállalat magatartása mindenben megfelel a törvényi követelményeknek, de miután a vállalat emberekből, olyan munkatársakból épül fel, amelyek esetében nem mindig tudja garantálni a törvényeknek megfelelő működést, ezért előfordulhatnak olyan deviáns viselkedések, amelyek visszahatnak a vállalatra. Hogy ez a hatás minél kevesebb legyen, minél alacsonyabb szintű legyen, ezért van nagyon fontos szerepe annak, hogy ezek a detektálások időben és megfelelően működjenek. Nézzük meg, hogy a vállalati compliance-nek milyen alanyai vannak. Magyarországon jelenleg a világ más országaihoz hasonlóan a nagy értékteremtő cégek azok, amelyek compliance rendszereket működtetnek. Esetenként még a középvállalkozások egy jelentős része is ide sorolható, ugyanakkor meg kell, hogy állapítsuk, hogy nem jellemző a compliance rendszerek működtetése kis- és mikrovállalkozási környezetben. Annak ellenére nem jellemző, hogy egyébként lenne erre igény, és fontos is lenne, hogy ezeknél a kisebb gazdálkodó szervezeteknél is megfelelő törvényi működés forduljon elő. Miért van ez így Magyarországon? Alapvetően azért, mert a magyar gazdaság struktúra meglehetősen sajátos. A nagy értékteremtő vállalatok a teljes vállalati struktúrának csupán a 10%-át, vagy az alatti mennyiséget adják, és a kis és azok, amelyek 90%-ban működnek a magyar gazdaság területén. Ez az egyik oka. A másik oka, nincs még megfelelő hagyománya Magyarországon, tehát Magyarországon ki kell alakítani a gazdaságnak ebben a szegmensében is a megfelelő compliance működést. Ugyanakkor azt is el kell, hogy mondjam, hogy várható változás ezen a területen. Miért várható változás? Azért, mert egyre inkább van egyfajta megfelelési kényszer, a piac által indukált megfelelési kényszer, amely abból adódik, hogy ezek a vállalkozások is részesei lesznek annak a beszállítói láncnak, amely a nagy értékteremtő cégek felé irányul, és ezen cégeknek a compliance politikája, ha úgy tetszik, lecsorog erre a gazdaságnak alacsonyabb vagy más fokán álló vállalkozások felé is. Milyen motiváció van Magyarországon arra, hogy ezek a compliance elemek minél inkább beépüljenek valamennyi gazdasági szereplőnek a tevékenységébe. Az egyik ilyen motiváció a nagy kárt okozó bűncselekmények elkövetésének megakadályozása. Ugye ennek is két vetülete van. Egyrészt a cégnek a saját belső érdeke, hogy ezt megakadályozza, másrészt pedig a tulajdonosi érdek, hogy ez megakadályozásra kerüljön. Alapvetően annak érdekébe, hogy ezek a bűncselekmények, ezek megelőzhetők legyenek, ennek érdekében mindent meg kell tenni, hiszen ez alapja a hosszú távon fenntartható fejlődésnek. Enélkül nem fog tudni működni vállalat. Maradva a saját szakterületemnél szeretném elmondani, hogy melyek azok a nem megfelelő cselekmények, ha úgy tetszik bűncselekmények, amelyek talán a leggyakrabban előfordulnak, és amelynek a felderítésére a compliance eszközök is alkalmazhatók. Tehát fiskális szempontból alapvetően a könyvek meghamisítása, a vesztegetés, tőzsdei információkkal való visszaélés, adatszivárogtatás vagy adatlopás lehetnek azok a cselekmények, amelyek nagyon negatívan tudják befolyásolni egy adott vállalatnak a külső piaci megítélését, és természetesen rendkívül kártékonyak a vállalat eredményességére. Nézzük meg, hogy milyen vállalati compliance elemekkel találkozhatunk. A vállalati compliance-nek a pilléreként a vállalati magatartási kódexet, a vállalati Code of Conduct-ot tekinthetjük. Ennek egy nagyon fontos eleme az, hogy ez ugyanúgy vonatkozik a vezetőkre és az alkalmazottakra. Tehát a vezetők nem kivételek, sőt, azt kell, hogy mondjam, hogy példamutatóak ezen a területen. Gyakorlati tapasztalatomból tudom mondani, hogyha az elmúlt 30 évben szerzett tapasztalataim alapján ma bemegyek egy céghez, és bemegyek egy vezetői irodába, vagy végigmegyek egy vezetői folyosón, nagy valószínűséggel meg tudom mondani, hogy mik azok a kihívások, amelyek mondjuk egy könyvvizsgálat, vagy egy adóvizsgálat során várnak rám, mert a vezetők hozzáállása az nagyon sokat elárul arról, hogy egy vállalatnál milyen megfelelőségi hozzáállással fogunk találkozni. Nagyon fontos további pillére a vállalati compliance-nek a belső sztenderdek és politikák kialakítása. Ez tulajdonképpen nem más, mint az adott jogszabályi környezetnek, a cégre vonatkozó jogszabályi környezetnek a cég életére történő lefordítása és beépítése a cég mindennapjaiba. Nagyon fontos ez a lefordítás szó azért, mert ezek a jogszabályi környezetek, ezek a megalkotott törvények, jogszabályok nagyon sokszor olyan módon kerülnek megfogalmazásra, amelyet adott nyelvről adott nyelvre le kell fordítani. Mindenki számára érthetően kell közölni. Tehát nem gondolom, hogy megfelelő egy olyan compliance standard, vagy egy olyan compliance code of conduct-nak a kidolgozása, amelyben csupán az adott ágazatra és szektorra vonatkozó jogszabályok felsorolása van benne, és kvázi mint egy követelményként, előírásként, hogy ezt mindenkinek ismernie kell, mert attól még egyáltalán nem biztos, hogy megértik. Folyamatosan képezni kell a kollégákat, és folyamatosan érthetővé kell ezeket tenni számukra. Értelemszerűen a mindennapokban különböző compliance eljárásokkal kell ezeket megjeleníteni, illetve érvényre juttatni. Kikényszeríthető-e, kérdőjel és felkiáltójel, vagy belső motiváció kell, hogy legyen ez a bizonyos vállalati magatartás, ez a fajta jogszabálykövető magatartás. Alapvetően az lenne a cél, és az lenne az ideális, hogyha egy önkéntes jogkövetés alap valósulna meg, az eltérő magatartás észlelése az mindenki számára egyfajta felkiáltó jelet jelentene, és mindenki számára azt jelentené, hogy ezzel kapcsolatban van valamilyen tennivalója. Ez a tennivaló lehet természetesen a legvégén az, hogy egy anonim csatornán keresztül, egy whistlebloweren keresztül valamiféle jelentést, vagy valamilyen olyan információnak az eljuttatását jelentse ez a döntéshozók felé, ami alapján ők meg tudják akadályozni ennek az egyébként nem jogszabályoknak megfelelő működésnek a terjedését. A jogszabályokkal, jogszabályi kötelező erővel ilyen módon csak egyfajta közvetett kapcsolat van, mert értelemszerűen a jogszabályok követelik ezt meg, de ugyanakkor egy belső önkéntes követés az, ami valamilyen módon megvalósítja ezt a fajta magatartást. Milyen területei vannak a vállalati compliance-nek? Itt megint maradnék a saját szakterületemnél, és ebből a szempontból nézném meg ezt a kérdést. Az eredmény és a profit szempontjából biztosítani kell a pénzügyi szabályozóknak való megfelelést. Mit jelent ez? A könyvelési sztenderdeknek való megfelelést, a pénzmosás és terrorizmus finanszírozásával kapcsolatos szabályok betartását, a könyvvizsgálati kötelezettség, mint egyfajta külső, objektív ellenőrzési lehetőségnek a kihasználását, kiaknázását és egyébként teljesítését. Aki könyvvizsgálatra kötelezett, az végeztesse is el ezt a fajta kötelezettséget, vagy ezt a fajta feladatot, tegyen ennek eleget. Az adózási szabályoknak való megfelelésnek a biztosítása. Adótervezés, adóelkerülés, adókijátszás. Ugye ezek is olyan fogalmak, amelyek folyamatosan előkerülnek. Nagyon vékony a mesdje, meddig vagyunk azon az oldalon, ami a jogszabályok által megengedett, és mikor lépünk át abba a mezőbe, ami már egyáltalán nem biztos, hogy elfogadható, vagy csak a jogszabályok sajátos, ha úgy tetszik, önkényes értelmezése alapján adhat alapot bizonyos adózási tranzakcióknak a megvalósítására. Ezeket nagyon fontos minden szempontból kiszűrni a vállalat működéséből. Fontos ez, mert ha hosszú távon akarunk gondolkozni, akkor lehet, hogy rövid távon nagyon jó cashflow szempontból mondjuk egy adó minimalizálás ma és itt, mert kevesebb adót kell fizetnem, de hosszú távon ennek biztosan valahol ára lesz. Tehát ezt a mai megtakarítást valahol vissza kell majd adnom. Ezeket a dolgokat kell mindig nagyon komolyan végig gondolni. Ez volt tehát az eredmény és a profit szempontjából történő értékelése ennek a területnek. A működés szempontjából az adott működési terület függvényében állandóan monitorozni kell a változó jogszabályokat, ebben szinten valamennyi jogág érintett lehet. A versenyjog, a munkajog, a környezetvédelmi szabályok, a munkavédelem, a fogyasztóvédelem, és még sorolhatnánk ezeket. Milyen eszközei, milyen megvalósítási módjai vannak ennek a bizonyos compliance-nek, a vállalati compliance-nek? Az iparági szabályozóknak a folyamatos ismerete szükséges ehhez, és monitorozása, ahogy mondtam az előbb, a céloknak és kockázatoknak az azonosítása, annak mérlegelése, és ha úgy tetszik, egyfajta prioritási sorrendnek a felállítása, hogy most mi a fontos számomra. Milyen kockázat van, ami nagyon gyorsan fenyeget, és amire azonnal reagálnom kell, és melyek azok, amelyek a hosszabb távú céljaimat szolgálják, és ebben a tekintetben talán van időm még a későbbiekben is cselekedni. Fel kell állítani megfelelő belső szabályozókat, meg kell határozni a felelősség és a felelősségre vonhatóságnak a szabályait, és ezt meg kell ismertetni az alkalmazottaknak. Ma már nagyon sok cégnél működtetnek dokumentumkezelő rendszereket. Ezeknek a beépítése azért nagyon fontos, mert rendkívül jól, egyszerűen, technikai úton követhetők azok a változtatások, amelyek az egyes dokumentumok kezelésébe, hozzáférésébe, módosításába végbe mennek. Ilyen módon akár könnyen kiszűrhetők visszaélések, és nyomon követhetők ezek, valamint az ezzel kapcsolatos költségek is nagyon gyorsan összesíthetők. Ugye itt felhívnám a figyelmet a költség-haszon elvre, hogy nem biztos, hogy bármilyen kismértékű szabálytól való eltérésre érdemes teljes körű fegyverzettel, ha lehet így fogalmazni, reagálni, mert lehet, hogy a költségek messze meghaladják annak a szabálytól eltérő viselkedésnek a károkozó képességét. Folyamatos belső tréningre van szükség, hogy mindenki tisztában legyen a saját felelősségével és a saját felelősségre vonhatóságával. És ezeket az értékeket egyébként célszerű a külső partnerek, beszállítók felé is kommunikálni. Mondok egy gyakorlati példát, lehet-e, és ha igen, milyen szintig ajándékokat például elfogadni? Ez ugye egy állandó, nagyon is akut kérdése ennek a fajta korrekt vállalati magatartásnak. Visszaélések jelzése esetén a hatóságok felé megfelelő lépéseket kell tenni, akár kooperálni velük, és a bizonyítékokat átadni. A vállalati compliance-nek az eszközei között megtaláljuk az Internal Compliance Team-et, akinek a vezetője egy megfelelőség ellenőrzési vezető, és egy ilyennek a felépítése, kinevezése és működtetése, ez a nagyobb vállalatok esetében természetes. Ahogy említettem az előadás során, az előadás elején, kisebb vállalatok ezt vagy nem engedhetik meg maguknak, vagy még nem tartanak ott, hogy ezt beépítsék a napi rutinjukba. A belső tréning és képzés, ennek a folyamatossága, rendszeressége minden alkalmazottra kiterjedő oktatás révén történő megvalósulása, ez nagyon fontos, hiszen állandóan változnak azok a sztenderdek, ami az a jogszabályi környezet, az a gazdasági háttér, amiben a vállalkozás tevékenykedik, tehát ebből a szempontból mindenképpen kiemelt jelentősége van neki. Vállalati kultúra kérdése. Itt megint a saját szakterületemnél maradva például egy úgynevezett tax risk management system vagy management rendszernek a működtetése szektorálisan, például akár az adókra vonatkozóan. Ez egyrészt segíti a szabályos működést, másrészt pedig preventív célja is van, tehát segít a megelőzésben. Ennek a folyamatnak ciklikus jelleggel kell megvalósulnia, azaz van egy mostani helyzetértékelés, van egy célmeghatározás, ahova el szeretnénk jutni, van egy tervezés, egy monitoring és egy válaszlépés arra, hogy hogyan alakítsuk a belső működésünket, hogy mindenben megfeleljük azoknak a kitűzött céloknak, amiket a jogszabályi megfelelőség megkövetel tőlünk. Eseti jelleggel ezek az eszközök, például a belső rendszeres audit, az éves kötelező audit, a külső adótanácsadó igénybevétele, őket lehet due diligence-re, úgynevezett átvilágításra, health checkre, különböző vizsgálatokra felkérni. Részt vehetnek az adótervezésben. Közvetett hatása van erre a folyamatra természetesen, például a DAC 6 irányelvnek és a jelentési kötelezettségnek, illetve az állami adóhatóságok adatbázisának a monitorozása, megbízható adózói partnerek keresése és a nyilvános fekete listák. És végül egy nagyon rövid kitekintés arra, hogy a vállalati szinten milyen külső és belső ösztönzői vannak a compliance-nek. Külső ösztönzők maguk az adójogszabályok, ezekkel szemben tartalmi és formai követelményeink vannak. Leginkább talán az lenne az egyik legfontosabb, hogy a túlzott adminisztráció elkerülhető legyen, és érthető, egyértelmű szabályaink legyenek, egy kiszámítható jogszabályi környezeten belül tudjunk dolgozni, és a belső ösztönzők kevesebb szabályszegés, hatékonyabb működés, jobb hírnév, amely nem csorbul, és amely lehetővé teszi megfelelő piaci előnynek a megszerzését. Azt hiszem, hogy ezek a legfontosabb elemei a compliance-nek. Köszönöm szépen, hogy részt vehettem, hogy elmondhattam az előadásomat, és kérdések esetén állok rendelkezésükre.
Mi köszönjük az előadás megtartását. Nagyon érdekes volt, és valóban új szempontokkal gazdagította az eddigi ismereteinket is, habár már a délelőtti szekciók körében is szó esett részben a vállalati compliance kérdéséről, de ilyen részletességgel kifejtve a mai napon még most hallhattuk először. Kérdést nem látok a chatboxban. Ti se láttok, ugye? Senki más nem lát a kollégák. Sorry, Professor Denecker, please.
I have one question. It was very interesting what you explained us. There is one point which is interesting for me. You said that an enterprise exists of individuals. And then in Germany, we had the impression that this is true, but not with compliance. With compliance, people take over the culture of an enterprise, and if they have a system of tax cheating, they accept it. On Sunday they go to church. On Monday they are cheating taxes. So for us, it was really interesting that it is not possible to reach individuals in an enterprise if the culture is not okay. So maybe this is different in Hungary, I don't know that. But in Germany, all interviews we made show that this is really difficult. And therefore, in Germany, at the moment, we think it's necessary to punish enterprises. That enterprises must change, and then people accept the culture of the enterprise. So, you know, this is another view we have at the moment in Germany.
Ha megengedi, köszönöm szépen a kérdést, professzor úr, röviden válaszolnék. Igen, teljes mértékben egyetértek azzal, hogy a vállalati kultúra az meghatározó az egyének szempontjából. Ugyanakkor én arra próbáltam rávilágítani, hogy ha van egy olyan vállalat, amely egyébként a compliance területen törekszik arra, hogy minden tekintetben megfelelően működjön, és ezen a vállalaton belül azonosítanak egy beteg sejtet, ugye az élő szervezeten belül, akkor elképzelhető, hogy annak ellenére, hogy a vállalat megtesz minden erőfeszítést, tehát megfelelő compliance szabályokkal rendelkezik, ezt megfelelően oktatja, ezt megfelelően dokumentálja, mindenki számára ismert, hogy milyen felelőssége és felelősségre vonhatósága van az egyénnek, mégis az egyén akár a helyzetéből adó kísértés következtében kerülhet olyan helyzetbe, hogy nem a vállalati compliance elveknek megfelelően működik. És ebben az esetben az egyén felelőssége kerül előtérbe, és ebben az esetben az egyén büntethetősége az, ami meghatározó, és ha a vállalat tudja bizonyítani azt, hogy ő megtett mindent, akkor én szerintem a vállalatnak a büntethetősége az csak másodlagos szinten jöhet elő, ha egyáltalán előkerülhet.
Yeah, I agree 100%. Thank you very much. This was interesting for me.
Thank you for a question and thank you for answer as well. Van-e még más kérdés, aki esetleg nem írta le, de szeretne kérdezni? Amennyiben nem, akkor áttérnénk a következő előadásra, ami szintén kapcsolódik már a délelőtt folyamán elhangzottakhoz. Akkor a német megoldást hallhattuk Trügg ügyvéd úrtól, hogy a védői szemszögből a vállalkozásokkal szembeni nyomozások milyen problémákat vetnek fel. Most hasonló kérdésekre fog kitérni előadásában dr. Sánta Ferenc. Be van kapcsolva a mikrofonom. Sorry. Tehát a kolléga felkonferálásánál tartottam, csak azt hittem, nekem szól a figyelmeztetés, hogy kapcsoljam be a mikrofon, de nem, ez már az előadónak. Tehát Sánta Ferenc egyetemi docens kolléga, aki a Miskolci Egyetemen a Bűnügyi Tudományok Intézetében közvetlen kollégánk is, de emellett ügyvédként is tevékenykedik, és így gyakorlati és elméleti szemszögből is meg tudja közelíteni a védő szerepét a jogi személyekkel szemben folyó büntető eljárásokban. Kérlek, Feri, nem látlak még, de látlak most már, hogy tartsd meg az előadásodat.
I don't know if you can see the PPT.
Yes, we can.
Okay. Thank you, Professor, the kind introduction. The title of my presentation is The Role of the Defense Lawyer in the Criminal Procedure Against Legal Person. So now I would like to concentrate on the procedural questions of corporate criminal liability, especially the role of the defense lawyer. But first of all, allow me to outline very shortly the relevant law, the relevant act, and the substantive features of criminal liability of legal persons. It might be useful, since Professor Dannecker mentioned that he is interested in the situation in Hungary concerning corporate criminal liability. So the relevant act and the substantial features of corporate criminal responsibility. In 2001, Act on Criminal Measures Applicable to Legal Persons was adopted, which is effective since the 1st of May 2004. As you can see, the Hungarian criminal legislator decided to enact a separate act instead of placing the relevant provisions in the criminal code. The substantive features of corporate criminal liability are of great importance for the initiation of criminal procedure against legal persons. The substantive features, the conditions, are the following. The first is the offenses for which the legal persons may be liable. According to the Act, any intentional crime defined in the criminal code may be relevant. My favorite and the simplest example is the crime of budget fraud, crime of tax fraud, which is committed in the framework of a corporation. The second is the natural person offender who engages in corporate criminal responsibility. There are three different situations in the Act. In the first case, the offender is the leader of the legal person, the so-called senior officer. In the second, any member or employee of the legal person, if the senior officer failed to fulfill a duty of control or supervision. In the third case, the offender is a person who does not belong to the legal person, the so-called outsider, and the senior officer knew about the commission of the crime. Think about, again, the budget fraud, where the natural person offender is typically the leader of the corporation. And the third necessary condition is the benefit to the legal person or using the legal person, because measures can only be ordered against legal persons if the crime aimed at or resulted in the legal person gaining some advantage, or the crime was committed by using the legal person. In case of a budget fraud, the illegal tax saving, the profit of the crime, is an advantage which appears for the corporation. We can see that all the three substantial conditions are fulfilled, and the criminal procedure may therefore be opened against the legal person. And let's look at the relevant provision of the Act. This is the Article 12. The Article 12 before 2008 and after 2008. Before 2008, the original wording of the text is the following: if any evidence is found in the course of the investigation that indicates measures could be taken against the legal person, the investigative authority shall immediately notify the prosecutor of this fact. The prosecutor shall decide whether the investigation should extend to the legal person. It is clear that the Act provided a great deal of discretion, a discretional power to the prosecutor in initiating and continuing the proceeding against the legal person. After 2008, the wording of the text, the first half is almost the same. If any evidence is found in the course of the investigation or on the basis of the complaint that indicates measures could be taken against the legal person, the investigative authority or the prosecutor extends the investigation to this legal person. If the investigative authority has decided to extend the investigation, it shall inform the prosecutor within 3 working days. It should be pointed out that this rule should not be taken to mean that the prosecutor loses its freedom to decide whether to charge the legal person or not, rather than to lose the possibility of hindering the proceedings against the legal person in the stage of the investigation. Once the prosecutor is in full possession of the information resulting from the investigation, he will be able to make a well-informed decision to prosecute or not. On the other hand, the role of the investigative authorities has also become more important, since they now have the right and are also obliged to investigate the legal persons. Consequently, I have to say, in principle, in all cases where the crime is committed within the framework of a corporation, and there are many of these cases, for example, economic crimes, crimes against property, environmental crimes, the investigative authority is obliged to extend the criminal procedure to the legal person. I'm sorry that the third slide is not operating, but I continue. The next topic is the procedural status of the legal person and the principle of parallel liability. As in certain other European jurisdictions, the Act contains the principle of parallel liability. It means that the liability of legal persons shall not exclude the possibility of criminal proceedings against the natural person perpetrator of the crime. Moreover, in Hungary, the sanctioning of the perpetrator as a main rule is the precondition for the liability of the legal person. The open questions are the status, the position of the legal person in the criminal procedure, and the "what do I call you" question. According to the Hungarian legal concept, a legal person cannot act, cannot be guilty, and cannot be a perpetrator of a crime. Consequently, the legal person cannot be a defendant, and it should not be entitled to the rights of the defendant. According to the Act, the application of the measure against the legal person shall be decided in the criminal proceedings against the accused. It follows that, as a main rule, it is not possible to prosecute the organization on its own. It is clear that the legal person is not a defendant, but it cannot be put into any other category of participant of the criminal procedure. So to answer to the "what do I call you" question is not easy, but the term of legal person under procedure can be accepted. I have mentioned that the sanctioning of the perpetrator is the precondition for the application of measures against the legal person as a main rule. Many questioned if it's useful or not, but there are several exceptions to this rule. If the perpetrator is not punishable due to his mental illness, death, voluntary restitution, or coercion, or if the natural person is not identified in the investigation, thus the investigating authority suspended the investigation, or the natural person is identified and charged but not convicted by the court, corporate sanctions may still be applied if the advantage appears for the legal person. In these circumstances, we can talk about a strange procedural situation. This is the case of the indictment without a defendant. This is problematic, not because of the fact that the criminal procedure is in progress only against the legal person in these cases, but the situation points towards the objective liability, a kind of objective liability of the legal person. To some, the status and the position, as well as the scope of the procedural rights of the legal person under procedure is rather uncertain. For example, how the presumption of innocence or the privilege against self-incrimination can be interpreted in relation to an entity. I agree with the critical remark found in the legal literature that the presumption of innocence does not apply in the context of the legal person, because the act obliges the investigative authority and the prosecutor to inform the court of registration about the initiation and conduct of the criminal procedure, as well as about the indictment. The court registers the content of these notifications into the public register, and does so in the phase of the criminal procedure when it is still questionable whether the legal person is really connected to the case and will be sentenced at all. This regulation is not in harmony with the presumption of innocence. It seems to me that the privilege against self-incrimination is also not applicable to a legal person, because it can be obliged to provide certain documents and electronic data, and this information could be used to determine its liability. And the next topic is the status and the role of the defense lawyer of the legal person. Since the legal person cannot stand trial, it is represented and defended by a lawyer on the basis of an authorization or an official appointment. The question, what do I call you, is also interesting in this context, because it is apparent that the lawyer is not a defense counsel, since only a defendant can have a defense counsel. Before 2017, the lawyer's name was the representative of the legal person. After a modification of the Act in 2017, the name is attorney acting on behalf of the legal person. The latter term appears to be more appropriate. The Act provides the right of the defense to the legal person when declares that if a measure may be applied against the legal person, an attorney or a registered legal advisor shall act in the interest of the legal person. If the legal person does not authorize an attorney, it shall be appointed by the investigative authority, the prosecutor, or the court. It follows from these provisions that the right to defense means a mandatory defense in a criminal procedure against legal persons. However, it should be stressed that the mandatory defense is not equal to the attorney's duty to be present at investigative actions, and he is not obliged to be present at these actions. This conclusion is supported by the Article 9, Section 6, which states that the attorney acting on behalf of the legal person before the filing of the indictment can be present at the interrogation of witnesses, provided the interrogation has been motioned by him, at the hearing of the expert, the presentation for identification, at the reconstruction of evidence, at cross-examination, if these actions are aimed at clarifying the legal person's relationship with the case. The next question is the presence of the attorney at the judicial stage of the criminal procedure. In Hungary, there are two main parts of the judicial stage, the preparatory phase and especially the preparatory trial and the court trial or court trials. Since the personal participation of the attorney is not explicitly required by the Act in the judicial stage, he or she is not obliged to be present. However, there is one exception to this rule, because the new article of the Act states that the presence of the attorney of the legal person at the preparatory trial shall be mandatory. The court summons the attorney to the preparatory trial, where he or she has a possibility to express its views on the prosecutor's motion concerning the legal person, to state the facts and evidence concerning the legal person, and to request the conduct of evidence and to request the exclusion of evidence. after the preparatory trial, the attorney is not obliged to be present at the trials. But in my opinion, the presence and active participation by the attorney at the trials is also very important, and a diligent attorney attends the trial and follows closely the evidentiary procedure. There are other important rights of the attorney of the legal person, since according to the Act, the attorney of the legal person exercises the rights of the defense counsel provided by the Criminal Procedure Code. For example, the right to read and copy the documents of the case concerning the legal person, to the right to file a motion and make an observation, the right to a legal remedy, and so on. The next question is how the attorney of the legal person will get into the procedure, the entering into procedure by the attorney. After the investigative authority has extended the investigation to the legal person, the authority is obliged to inform the legal person about this fact and to warn it that if the legal person does not authorize an attorney, the investigating authority will appoint a lawyer. This is the point when the attorney of the legal person enters into the procedure. But I note that if the leader, if the senior officer of the corporation has become a suspect, for example, in a budget fraud case, the corporation is strongly advised to prepare itself for a possible criminal procedure. There is an important main rule. The attorney of the legal person is authorized by a legal representative of the legal person. The first exception to this rule is that the defendant, his relatives, and his defense counsel have no right to authorize the attorney of the legal person. And the second is that the defense counsel of the natural person defendant shall not be the attorney of the legal person. The aim of the legislator was probably to avoid the conflict between the interest of the defendant and the interest of the legal person. It is another question that, in my view, the interest of the legal person and the defendant are usually the same. Consequently, the defense counsel of the defendant and the attorney of the legal person will find each other because the defendant and the legal person cry and laugh together because according to the Article 16, Section 2 of the Act, if the procedure against the defendant is terminated or the defendant is acquitted, the procedure against the legal person shall also be terminated as a main rule. And finally, the attorney in the criminal procedure against legal person, since I have been involved in a criminal procedure against a legal person before, I can say that this type of procedure is almost no different from a traditional criminal procedure. In this case, the attorney of the legal person essentially behaved as a defense counsel. During the evidentiary procedure, he made observations and asked questions to the witnesses. According to the Act, after the closing of the evidentiary procedure and final speeches of the prosecutor and the defense counsels, the attorney of the legal person has the right to speak in the interest of the legal person. Despite this rule, the attorney held a classic defense speech like a defense counsel. It's just interesting that in this case, the court imposed a fine, a criminal fine against the legal person, but the written court judgment, which lasted hundreds of pages, dealt with the issue of criminal liability of the legal person only in about 1.5 pages. Finally, I would like to highlight just a few statistics about the Hungarian practice of corporate criminal sanctions. From 2004 to 2008, when the prosecutor had a discretion to initiate the procedure against the legal person, sanction against the legal person has been proposed by the prosecutor totally 7 times, only 7 times. From 2009 to 2019, when the investigative authority is obliged to extend the investigation to the legal person, the number of the prosecutor's motion is 228. We can see the positive point concerning the modification in 2008. The number of criminal procedures against corporations has significantly risen. Criminal responsibility of legal person is a reality now in Hungarian criminal law. Effective and deterrent measures against legal persons are available, and our duty is to implement these provisions into practice. Thank you for your attention.
Thank you for your presentation. I cannot see any question at the moment. Van esetleg kérdés a résztvevők részéről, megjegyzés? Nincs Jacsó Judit professzor asszony szeretne hozzászólni. Át is adom a szót, parancsoljon. Nem, most már kezdjétek. And after Judith, okay, so Professor Dannecker, put your question, please, or your comment.
I have one question. Thank you very much for this wonderful lecture you gave us. We had more or less the same situation in Germany, but our highest court, they decided that a lawyer of the individual at the same time can be the lawyer for the enterprise. But this is crazy. This is not possible. And you said, no, you couldn't accept that. But is it really true that the enterprise and the individual cry and laugh together? Or can the enterprise laugh if they have a claim against the private person? In Germany, we have very often the responsibility for damages of the individual, because the individual caused the penal responsibility of the enterprise. And so our courts decide, therefore, the individual has to pay part of the penalty, of the fine against the enterprise. So you have not the same interests, but the interests then are against, you know. How is it here in Hungary? Do you have claims against the directors of an enterprise, or does this not exist?
Pedig válaszolsz rá? Válaszolsz a kérdésre, vagy megvárjuk a többi kérdést?
Igyekszem válaszolni erre a kérdésre. Én úgy gondolom, hogy ha az adott bűncselekményt azt a jogi személy érdekében valósította meg a természetes személy elkövető, tehát akár a jogi személynek a vezetője, akár alkalmazottja, tagja, akkor a Dannecker professzor által említett kártérítésre, amit maga a cég nyújtana be tehát a természetes személy elkövetővel szemben, nálunk bizonyosan nincsen lehetőség, még akkor sem, hogyha noha megállapítják a természetes személy elkövető mondjuk a vezető felelősségét, de a bíróság a jogi személlyel szemben büntetőjogi szankciót nem alkalmaz. Legalábbis jogszabály alapján így gondolom.
Köszönjük szépen, és akkor most közben Sawyer professzor úr jelentkezett be. Professor Sawyer, please.
Yeah, I have a question. I understood that the natural person is not allowed to have the same lawyer as the corporation. Gerhard Dannecker also addressed this. Then you said they have the same interests. This is not clear for me because in our systems, there are some same interests, but there are also conflicts of interests. There is a defense for the corporation, which helps the corporation, but which is not so good for the individual, and vice versa. There are some very clear conflict of interest situation where the one player can help himself, but it is to the damage of the other one. So could you explain how they have in general all the same interests? I don't understand.
Igen, én ezt a következtetést, amit itt megfogalmaztam, azt kizárólag a vonatkozó jogszabályi rendelkezés alapján mondtam, amit idéztem is, mert hogy a magyar törvény szerint az a fő szabály, hogyha egy olyan eljárásban, amelyben mind a természetes személyt megvádolták, mind a jogi személlyel szemben intézkedés alkalmazását indítványozta az ügyészség, akkor abban az esetben, hogyha a természetes személy elkövetőt felmenti a bíróság, vagy vele szemben megszünteti az eljárást, akkor főszabály szerint így tesz a jogi személy vonatkozásában is, vagyis a ügyészség indítványát elutasítja. Tehát én ennek alapján mondom, hogy együtt sírnak, együtt nevetnek, és ezért fog szerintem a magyar büntetőeljárásban egymásra találni a természetes személynek a védője, a terheltnek a védője, és a jogi személynek a védője. Én ezt a tapasztalatok alapján mondom, hogy ők együttműködnek. Mert ha az ügyben sikerül azt elérni, hogy a természetes személy elkövetőt felmentik az ellen emelt vádak alól, akkor főszabály szerint a jogi személlyel szemben is meg fogják szüntetni az eljárást. Elfogadom azt az álláspontot, amit a professzor úr is kifejtett, azt hiszem most az előadásában, hogy természetesen előfordulhat olyan forgatókönyv is, hogy a jogi személy, a vállalat megpróbálja bűnbakként beállítani a természetes személy elkövetőt. A tapasztalatok alapján Magyarországon én nem ezt a verziót látom, hanem inkább az elsőt, amit én említettem.
Köszönjük szépen, és akkor Jacsó Judit jelentkezik.
Jó, köszönöm.
Mert le is...
Nem, igen. Köszönöm szépen, csak a délelőtti szekcióban volt egy kérdés a lengyel kolléganőtől, Beáta Barántól, aki azt kérdezte, hogy a közszférában a compliance kötelező jelleggel megjelenik-e, és a magyar szabályozással összefüggésben szeretném megjegyezni, vagy kiegészíteni az eddig elhangzottakat azzal, hogy a köztulajdonban álló gazdasági társaságokra vonatkozó kormányrendelet az előírta 2021. január 1-től a belső kontrollrendszer részeként megfelelést támogató szervezeti egység, vagy pedig tanácsadónak a bevezetését az adott gazdasági társaságnál. De még egyszer hangsúlyoznám, hogy ez a köztulajdonban álló, tehát ez tulajdonképpen a közszférában a compliance-nek a megjelenése, és ráadásul nem a soft law, hanem hard law keretében jelenik meg Magyarországon is. Úgy gondoltam, hogy ezt mindenképpen érdekességképpen a diszkuszió kapcsán megosztanám a hallgatósággal. Köszönöm szépen.
Látom. Köszönöm szépen. És írásban is érkezett egy kérdés Sánta Ferenchez, lehet, hogy látod is, Feri, a chat ablakban. A kérdés így hangzik: lát-e jogalkotási igényt, szükségességet a jogi személy büntetőjogi felelősségével kapcsolatosan? Kérdezte Szikszai Tibor Nyíregyházáról. Megadom a szót, ha válaszolni szeretnél rá, és kérlek is,
Igen, köszönöm szépen a kérdést. Gondolom a kolléga esetleges törvénymódosításra gondol alapvetően nyilván a jogszabály tekintetében. Sokat formálódott ez a jogszabály egyébként az évek során. Én, amit korábban is már leírtam, illetve hangsúlyoztam, talán a magyar büntetőjogi szankciórendszernek a bővítése, tehát a jogi személlyel szemben alkalmazható szankciók bővítése, a szankciórendszer bővítése lehet adott esetben egy további lépés, hiszen gyakran elhangzik az a kritika, hogy a magyar szankciórendszer ebben a tekintetben, tehát a jogi személlyel szemben alkalmazható intézkedések tekintetében, hát meglehetősen kevés szankciót tartalmaz. Ugye ismeretes, hogy 3 darab szankciót ismer a magyar törvény. Ez a legsúlyosabb szankció a jogi személy megszüntetése, a tevékenységének a korlátozása, illetőleg a pénzbírság. Negyedikként egyébként alkalmazható a hagyományos intézkedésként szabályozott vagyonelkobzás, de adott esetben de lege ferenda javaslatként lehet megfogalmazni a szankciórendszernek a bővítését, például olyan jellegű szankciókkal, mint a más külföldi jogokban vagy nemzetközi dokumentumokban ezek ismert szankciók, mint a bírósági ítélet közzététele adott esetben, vagy a jogi személy felügyelet alá helyezése. Tehát én ebben látnék még fantáziát az esetleges törvénymódosítással összefüggésben. Köszönöm.
Köszönöm szépen. Kérdés sincs több, és időnk sincs több arra, hogy kérdésekkel, megjegyzésekkel foglalkozzunk, hiszen át kell adnom a szót a következő, és egyben a szekcióban utolsó előadónak. A következő előadónk Mirta Kustán lesz, akinek az előadása mint egy keretet ad a mostani szekciónak, hiszen azt az osztrák nyomozásra vonatkozó szabályok megismerésével kezdtük, és most zárásként a horvát büntetőeljárásjognak a nyomozásra vonatkozó szabályaival ismerkedhetünk meg. Többek között azzal, hogy milyen sok hatóság rendelkezik nyomozó hatósági hatáskörrel, lát el ilyen feladatokat, hogy ez mennyiben bonyolítja meg a nyomozás lefolytatását, arról már Mirta Kustán fog nekünk szólni a következő néhány percben. Ezzel át is adnám a szót. Mirta Kustán, the floor is yours. Please switch on the micro.
We cannot hear, so use the mute.
Hi, sorry, I didn't unmute myself. Thank you, Professor. I will now share my presentation. Okay, can you all see it?
Yes, we can.
Okay, so hello everyone, my name is Mirta Kustán. I am assistant at University of Zagreb Law School at Criminal Procedural Law Department. And today I will talk about specialties of criminal and administrative investigations, interoperability between those procedures in Croatia. So regarding contents of this presentation, I will refer in short on criminal and administrative proceedings in Croatia, and then I will explain which other investigative bodies exist in our legal system, other than police and state attorney. So, as we all know, the purpose of criminal proceedings is to determine in the manner prescribed by law whether a criminal offense has been committed and who committed it, and then apply a punishment or other appropriate measure. On the other hand, in administrative proceedings, state administration bodies and legal entities with public authorities decide on the rights and obligations and legal interests of citizens and other entities in certain administrative matters. In most cases, Croatian criminal proceedings are initiated by state attorney ex officio, and a state attorney is the master of preliminary proceedings and combines the functions of prosecution and investigation. Criminal inquiries are performed by police officers outside of the criminal proceedings and mostly in informal manner. Afterwards, if state attorney considers that there are grounds for suspicion that a certain person has committed a criminal offense that is prosecuted ex officio, he is obliged to undertake criminal prosecution and to conduct an investigation for criminal offenses punishable by a long-term imprisonment. Also, if investigation shall be conducted for criminal offenses punishable by imprisonment for term exceeding 5 years, unless the results of actions related to criminal offense and the perpetrator provide sufficient grounds for the indictment. Moving on to the administrative proceedings, there are 3 ways to start administrative proceedings. At the request of party, proceedings are generally initiated to grant a specific right, while ex officio proceedings are generally initiated to impose obligation on the parties. And procedure is initiated by a public announcement when the parties are unknown or if such procedure is prescribed by law. The bodies before which administrative proceedings are conducted are diverse, from central state administration bodies to competent bodies at local level. And the type of body depends on the nature of administrative matter. In administrative proceedings, as evidences, there are certain documents, witnesses, experts, also inspection or party statements. It is also important to mention that with respect to existence of criminal act and criminal liability of the perpetrator, the administrative body conducting the procedure is bound by a final judgment of criminal court. And also, the procedure must be terminated when the preliminary question relates to existence of criminal act, and there is a possibility of criminal prosecution by competent judicial body, or if such procedure is already ongoing. So here you can see the list of other investigative bodies and special investigations that I will talk about, which include Sector for Financial Investigations, Anti-Fraud Coordination Service, AFCOS, Air, Maritime and Railway Traffic Accident Investigation, the Head of Administrative Investigation in Maritime Accidents, State Audit Office, and State Inspectorate. And also I will refer to 2 examples of independent forensic examinations, research and expertise providing bodies. So starting with Independent Sector for Financial Investigation, it was set up within the Tax Administration Central Office. Its jurisdiction is over all taxpayers in Republic of Croatia. ISFI performs financial investigations in cases where there are serious indication of organized crime, corruptive criminal offenses, and criminal offenses of subsidy fraud against European Union funds. Moreover, analysis of complex international transactions are organized within the special office. This is a separate team of investigators specialized for investigations of sophisticated, complex international transactions and monitoring operations of foreign business entities in Republic of Croatia. This body also analyzes possible illegal outflow of Croatian taxpayer assets abroad. So the role and the main task of this sector is to detect and investigate persons with high risk, indicating organized crime, corruptive criminal offenses, and criminal offenses of substantive frauds. The next task is to provide support to all criminal prosecution authorities and intelligence agency in a form of financial analysis and investigations. And also, this body tries to encourage taxpayers to voluntarily meet their tax obligations. So here you can also see the bodies that are set up within the sector of financial investigations. The financial investigations include inquiries and actions to find and identify illegally acquired property, money laundering, and other property against which security measures should be taken in order to confiscate the proceeds of crime and collect the equivalent. Financial investigation is undertaken in connection with criminal proceedings of criminal offenses that generate illegal property or organized crime when it's necessary to search for such illegal property. Also in connection with suspicious financial transactions and activities, economic crime, tracking money, money laundering, for example, when it's necessary to process a suspicion transaction notification. The financial investigation, or more precisely, the financial inquiries, are conducted at the same time as criminal inquiries or after. And while the aim of conducting regular investigation is to detect criminal offenses and perpetrators and collect evidence that enables the submission of an investigation request or indictment, the aim of parallel financial investigation is to confiscate the proceeds of crime. The activities of financial investigation, here you can see them, and they include checks of records of tax administration, custom administration, land books, banks, central depository agency, and so on. So now AFCOS. AFCOS is so-called Croatian OLAF, through which direct cooperation with European Anti-Fraud Office is ensured. And basic task is the protection of financial interest of European Union in Republic of Croatia and establishing a system to combat irregularities and fraud, for which it can propose legislative and other measures. AFCOS assists and coordinates OLAF's investigations, forwards information received from OLAF to all competent authorities, and submits annual reports on work and irregularities observed. The AFCOS network includes representatives of Ministry of Justice, Ministry of Interior, Ministry of Finance, where most important is Service for Combating Irregularities and Fraud, which I will talk in the next slide about. Then Ministry of Economy, State Attorney's Office, and Agency for the Audit of European Union Programs Implementation System. So the Service for Combating Irregularities and Fraud is organizational unit for supervision of irregularities and fraud set up within the Ministry of Finance. And this is main contact point for OLAF in Republic of Croatia. As a main contact point, this organizational unit ensures that OLAF inspections are carried out in the territory of Republic of Croatia. It receives and controls reports on irregularities and sends them to OLAF, and coordinates legislative, administrative, and operating activities between bodies in the AFCOS system. This service is also responsible for receiving and checking reports on irregularities, develops training programs, and monitors the recovery of illegally disbursed EU funds. So now we can see criminal offenses related to the use of EU funds, subsidy fraud, business fraud, abuse in the public procurement procedure, tax or custom evasion, illegal favoritism, and other corruption offenses. Now, Air, Maritime and Railway Traffic Accident Investigation Agency. This is an independent body for the investigation of accidents in air, sea and rail transport. These safety investigations are conducted autonomously with the aim of determining the causes of accident and issuing safety recommendations. Activities of this agency include investigations of serious aircraft accidents, safety investigations for the purpose of determining the cause of maritime accident, and proposing measures to avoid maritime accidents and improve navigation safety. And also research into serious railway accidents and emergencies. Also, this agency exchanges data from its database with other investigative bodies and provides professional assistance to competent investigative bodies of Republic of Croatia. Administrative investigation of a maritime accident is carried out independently of before mentioned safety investigation of maritime accident. This investigation is carried out when there are bases for suspicion of committing a maritime misdemeanor in connection with the events of maritime accident. The head of administrative investigation is appointed by a port captain of the local competent port authorities, and only an official who performs the task of inspection supervision and navigation safety and who is qualified to conduct investigation of maritime accident can be appointed. It is important to mention that if a competent state authority initiates criminal prosecution for criminal offenses which also include a maritime misdemeanor related to some sort of maritime accident, administrative investigation is not carried out or stops. In that case, the state attorney shall be provided with all evidence and data collected so far on maritime accident. The investigation of maritime accident ends with the issuance of misdemeanor warrant, the filing of an indictment, or a decision not to initiate misdemeanor prosecution. The work of State Audit Office is focused on auditing financial statements and business operation and improving the legality and effectiveness of entities managing public property and other legal entities defined by law. Moreover, it contributes to improving management of public property and other available resources and informs Croatian Parliament, government, and citizens of Republic of Croatia about the manner and results of management of budgetary, extra-budgetary, and other funds given to the audited parties for management and disposal. The office also has jurisdiction to audit the European Union funds and other international organizations or institutions for funding public needs. It is important to mention that its operations are independently and autonomously conducted. The State Inspectorate performs inspections related to the supervision of operations and the implementation of regulations on trade goods, labor and safety at work, mining, pressure vessels, fresh water, hunting, forest seeds, tourism activities, and so on. The State Inspectorate also performs inspection tasks in other administrative areas when determined by a special law. And here we can see that there are many different types of inspectors: economic, labor, electric power inspector, mining, and so on. In the end, I would like to mention two examples of independent forensic examination, research, and expertise providing body, which are of great deal of importance to public and private sector investigations. Firstly, there is INSIG2. It's a company specialized for integrated security solutions and digital forensic solutions and services. Since 2004, INSIG2 has been providing services for law enforcement authorities, defense authorities, legal bodies, banking institutions, pharmacy, public health institutions, and many more. Secondly, Forensic Science Center Ivan Vučetić. This is independent organizational unit that performs completely independent forensic examination research and expertise, such as identification, chemical, physical, toxicological, contact, technical, digital records, and so on and so on. And it does so by the order of State Attorney Office, court and police, and on the basis of agreement with other bodies. The center is responsible for the National DNA database, as well as the National Fingerprint database, and collection of bullets and castings from unsolved national criminal cases. And the center has close cooperation with various scientific institutions, such as veterinary faculty, faculty of science, police academy, faculty department for forensic science, and many more. To finish up this presentation, I would like to state few important things. Often individual violations, offenses, misdemeanors are covered by various regulations and laws, which leads to the possibility of undertaking various investigations. And the questions are raised about the use of evidence and knowledge gathered in one type of investigation in different type of investigations and proceedings. And this is particularly problematic, in criminal proceedings. So, documentary evidence gathered in administrative investigation can always be used. But on the other hand, testimonial evidence cannot be used in criminal proceedings because of the protection of human rights and ensuring the right of defense, but also ensuring the fair trial in which fair tribunal directly examines the evidence. Just shortly about the simultaneous investigations, as I already stated, investigations of AFCOS and financial investigations are conducted at the same time as criminal inquiries or after, and have a purpose also in criminal proceedings. On the other hand, administrative investigation of a maritime accident has to be terminated if a state attorney initiates criminal prosecution. The important question is also the one on the ne bis in idem. But as we are limited in time, and I'll have to leave that for some other occasion where there will be more time to research into this problem and talk about in depth. So I will now, given that the time is limited, stop. Thank you everyone for the attention.
Thank you for your interesting presentation. Egyelőre nem látok kérdést. Kíván-e valaki kérdést feltenni az előadóhoz? Amennyiben nem, akkor azt kell, hogy mondjam, hogy a csúszással felhalmozott plusz időből legalább egy kicsit lefaragtunk a szekció végére, és nagyon röviden szeretném csak összefoglalni a szekcióban elhangzott előadásokat, nem vállalkozva nyilván azoknak a tartalmi kivonatolására, csak azt szeretném jelezni, hogy mennyire komplex a mai konferenciánk, mennyire összefüggenek egymással az előadások. Ebben a szekcióban voltak olyan előadók, akiknek a témája a délelőtti szekciókhoz kapcsolódott, és elkezdtük azt a vonulatot, amit majd a negyedik szekció fog tovább folytatni, nevezetesen, hogy az egyes nemzeti jogszabályok ismertetésére, és nem csak a jogszabályok, hanem a gyakorlat ismertetésére is sor kerül. Ebben a szekcióban ugye az osztrák, illetve a horvát megoldásról kaptunk egy rövid, vázlatos képet. Ezzel szeretném megköszönni az előadóknak a felkészülését, a valóban nagyon érdekes előadásokat, és a résztvevőknek az aktív részvételt, a kérdéseket, megjegyzéseket. A következő szekció vezetője Nagy Anita professzorasszony lesz, aki ugyancsak a Miskolci Egyetem egyetemi tanára, a Bűnügyi Tudományok Intézetében kollégánk. Ezzel megköszönve az elhangzottakat, az előadásokat, át is adom a szót Nagy Anita professzorasszonynak. Parancsolj, Anita!
Köszönöm szépen a lehetőséget, és köszönöm szépen, Erika, hogy átadtad a szót is nekem a délutáni 4. szekciónak a megkezdésére, és minden esetre én is sok szeretettel szeretném köszönteni a délutáni 4-es panelnek a résztvevőit. Ebben a panelben 3 előadást fogunk meghallgatni, de mielőtt erre sor kerülne, csak emlékeztetőül egy pár technikai információra ismételten, akkor hadd hívjam fel én is a figyelmet. Tehát ugyanúgy továbbra is a chaten van lehetőség feltenni kérdéseket, illetőleg, hogy aki most kapcsolódik esetleg be, a tolmács funkcióra kapcsolva lehet elérni a magyar, illetőleg az angol nyelven az előadásokat. Aki eddig esetleg nem tette meg, arra továbbra is kérnénk, hogy a jelenlétívet azt legyen kedves aláírni, elküldeni, visszaküldeni, illetőleg az előadók felé továbbra is a kérésünk, hogy ezt a 20 perces időt tartsák meg, hogy amennyiben, és úgy, hogy ezt nyilván ezeket az előadásokat tolmácsok felé jól prezentálva legyenek. Akkor az első előadásra felkérném tisztelettel a Nagyváradi Egyetem dékánját, professzor dr. Krisztián Mihezt, aki a munkáját Diana Kurmacsú dékán helyettes asszonnyal együtt készítette el. Az előadásnak a címe a nyomozás szerepe a nemzeti jogban Romániában és a határokon átnyúló büntető eljárásokban, különös tekintettel az Európai Unió pénzügyi érdekeit sértő bűncselekményekre, amelyet tehát Krisztián Mihez professzor úr fog számunkra ma prezentálni. Akkor át is adnám neked, Krisztián, a szót, akkor így kedves megtartani az előadásodat.
Thank you very much. Köszönöm szépen. I hope I can synthesize the things I want to say, because there are so many things under this umbrella of criminal investigation, and more or less there are sensitive things. First of all, let me thank you in the names on behalf of let's say Oradea team. Let me thank you for the invitation and for the fact that we are part of this second Hercule project. We have prepared an overview, both from substantial and procedural point of view. And we will like to highlight in the second part of our presentation some procedural aspects that are connected to the investigation in this field. I would like to share. Please tell me if you can see the slides. It's okay. I hope it's okay. First of all, what is the premises for our endeavor? We have the treaty to access for Romania's accession to the European Union in 2007 in force. Since that moment, we have deposited, let's say, a lot of effort in order to achieve what we are calling the communitary acquis. As one of the results is the law 78 from 2000 that was adopted in 2000 and was more or less one of the first instruments in countering or combating acts against the financial interest of European Union from criminal law point of view. However, in that context, the Romanian legislator has underestimated one of the most important problems which has overall affected the Romanian law system over the last 30 years, namely the normative excess. I will make some details. I will present some details around this matter. Furthermore, I would like to underline that the direction assumed by our country was to transpose into the national legislative system numerous regulations, directives, including those related to the protection of the EU financial interests. As a consequence, as I said before, we have the law 78 from 2000, which deals actually from the title with corruption. And within this law was included in section 4, index 1, were included the offenses against the financial interest of the European Union. So they were not included in the law from the beginning. They were included a few years after the initial adoption of the law. We have 3+1, let's say, offenses here regulated, and I will present them in short, not to deep into the analysis, since our main concern is at this moment the procedural aspect. So we have Article 18, Index 1, the use or presentation of false, inaccurate, or incomplete documents or statements if the deed results in the unjustified obtaining or unjustified withholding of funds or assets from the budget of European Union or the budgets administered by European Union or in its behalf, shall be punished with imprisonment from 2 to 7 years. Initially, the punishment was more severe, from 3 to 15 years, but over the years it decreased up to this level. This level has a significant, is important from procedural aspect, since up to 7 years, if the crime is punishable up to 7 years at that time, at the 2000, then a plea bargain could have been concluded between prosecutor and the defendant. Furthermore, in the next paragraph, we have the same punishment, which sanctions the omission to provide knowingly the data required according to the legal provisions for obtaining or withholding funds or assets from the budget of European Union or the budget administered by it or on its behalf, if the deed results in unlawful obtaining or retention unjustifiably of these funds or assets. And the last paragraph deals with particularly serious consequences. This means consequences in the value, in the amount of approximately 400,000 euro. Furthermore, we have Article 18, Index 2. The change without observing the legal provisions of the destination of the funds or assets obtained or retained from the budget of the European Union or from the budgets administered by it or in its name is punished with imprisonment from 1 to 5 years and prohibition of exercising certain rights. Also, we have another offense, the change without observing the legal provisions of destination of obtained legal benefit if the deed results in an illegal diminution of resources from the budget of European Union or from the budget administered by it or in its name. It is sanctioned with the same punishment provided in the previous paragraph. The last one in this chapter of the law, we have Article 18, Index 3, which is more or less similar with the first one I have presented. The use or presentation of false, inaccurate, or incomplete documents, which results in the illegal diminution of the resources to be transferred to the budget of the European Union or to the budget administered by it or on its behalf. So the main difference between Index 1, 18 Index 1 and 18 Index 3 is the fact that in the last case, we have the resources, the protection is the object of the protection are the resources to be transferred to the budget of the European Union. Also, it is sanctioned as a criminal offense, the omission to provide knowingly the data required according to the legal provisions. If the deed results in an illegal diminution of resources to be transferred to the budget of the European Union, the budget administered by it or on its behalf. A total, let's say, novelty in our law, especially criminal law system, total novelty is connected with this next offense we are presenting, 18 Index 5, which is from subjective point of view has a different approach, since we are dealing here with a faulty violation committed by the director, administrator, or the person who has decision or control within an economic operator of a duty of service, but its non-fulfillment or its defective fulfillment, if the deed resulted in the commission by a person who is under his subordination and who acted on behalf of that economic operator of one of the offenses provided before. Here is a little mistake in Article 18 Index 1 up to 18 Index 3, or committing a crime of corruption or money laundering in connection with European Union funds. We have the sanctioning here, imprisonment from 6 months to 3 years or a fine. I want to get back to the first offense I have presented. We had a dispute within the jurisprudence, and the dispute was solved, let's say, by the High Court of Cassation and Justice, that who established in 2020 that the person who commits both the deed presented in 18 Index 1, and since it includes the false, inaccurate, complete of documents and statement, includes forgery, the person who commits the offense stipulated in Law 78 from 2000 and the forgery stipulated in the Criminal Code is punishable for both offenses in real competition. So the High Court considered not to absorb the crime of forgery into the crime stipulated from Article 18 Index 1. Furthermore, if we are going to the procedural part of our presentation, then we must underline that the offenses provided by this law 78 from 2000, in case of offenses, these offenses, the criminal investigation must be carried out by the prosecutor. And also precautionary measures must be taken in all cases. There is no exception. We have a problem with that attempt, problem that was solved partially by the Constitutional Court, but we have, let's say, another problem today when we are the public ministry from Romania, who is overseeing the activity of the prosecutors, is dealing with the division of the case in between them, the National Directorate of Anti-Corruption, and the EPPO. Some special provision for detection and prosecution of criminal offenses. The person who has control attribution is obliged to notify the criminal investigation body in all cases. In all cases, he is obliged, he or she are obliged. They are obliged. Also, the person who is carrying out a control during the performance of the control, if he or she finds out some certain aspects that are connected. Sorry. I have to, I'm sorry. I did not see the messages on the terminal, sorry. On Hungarian. It's okay. Maybe now. I turned it out. Okay, I'm sorry. A misunderstanding. So I was saying that there are certain persons who have the duty to notify the criminal investigation body when they are aware of aspects that are connected with the protection of financial interest during exercising their duty, or more important, during the control. In the last case, they also have to take certain preservation measures as regarding the traces of the crime, as regarding the corpus delicti or the other evidence. Since I lost a few minutes, I will go a little speedier. Also, we have an obligation, procedural obligation from the persons who are more or less in charge with the corporate and juridical entities, that they have also the obligation to notify the investigation body, or as the case may be, the bodies for ascertaining the commission of the crime, or the control bodies authorized by the law. When sums, goods or money that are supposedly influencing the protection of financial interest of EU are involved. More or less, one of the most important provision from this law is that the banking and professional secrecy, except the professional secrecy of the lawyer exercised under the law, are not opposable to the prosecutor after the start of criminal investigation, nor to the court. For the trial in the first instance of the crime provided in the Law 78 from 2000, specialized panels are set up. For both of these aspects, we have strong debates in Romania. In the first case, for the expression exercised under the law, and which are the limits of the defense you have to provide for your client as a lawyer. And in the second aspect, these specialized panels are very much debated also under the jurisprudence of Constitutional Court. Furthermore, if I have to can you hear me?
Yes, we can hear you.
Okay. So I have within the presentation we have included a lot of technical data, statistical data. Maybe is not suitable for this late hour now, but I would like to underline some aspects. However, if we are looking for the plea bargaining agreement, as discussed in the session in the morning, in the last period in 2020, there were 46 plea bargaining agreements closed, 41 for natural persons and 5 for legal entities, for which the competent courts were notified. In this respect, there was an increase compared to the previous years in the number of agreements concluded, given the fact that in 2019, only 38 were registered, in 2018, only 12 such agreements were registered. From this point of view, it is important to underline the significance of the Article 478 from Criminal Procedure Code, which denotes, we say, the efficiency of the way of completing the criminal investigation activity and of the strategy adopted by the prosecutors in order to avoid costly and long-lasting criminal trials. Unfortunately, also in Romania, we have trials, criminal trials that are lasting long, too many, not months, but too many years. If we are passing to the sources, what are the sources for investigation and prosecution? We can see that the offenses perpetrated within the branch of agriculture and rural development are predominant. In this respect, we had 63 cases last year. As regarding the modus operandi, the investigation of these crimes, of course, is a complex activity. In many cases, we have encountered a very well-developed way of operation, patented and replicated by the same people on the occasion of different requests for funds, establishing and interposition of companies controlled by the fraudulent beneficiary, or distortion of public tenders organized for the purchase of equipment in such a way that they were awarded at prices well above the market value, with the subsequent recovery through the fictitious contracts by the beneficiary of a price difference. These two are the most common methods of perpetration. Closing, I want to refer to a recent decision that affected, let's say, our presentation, since this is a decision from 18th of May 2021, which deals with the, let's say, reforms we have performed into the justice system in the last years of in Romania, in the last 3 years of Romania. There were 6 preliminary rules addressed to the Court of Justice from the European Union, and one of them dealt with supremacy or primacy of the EU law, because there were decisions from the Constitutional Court, or more from the Constitutional Court, not so many from the High Court of Justice, but from the Constitutional Court, that were considered by certain judges not in accordance with the European law. And there was a question to what should they do? Because they, from internal point of view, internal rules point of view, they had to observe the decision of Constitutional Court. Otherwise, they could be held disciplinary responsible, or they will apply directly the European law. Summarizing, the Court of Justice from Brussels did say that they have, or they can, not they have, they can apply directly the European law. Final remarks. Recent decision I have mentioned, it's practically a change of approach. The investigation techniques must be updated to the means of perpetration. We have the problem of overlapping legislation, as in forgery and we have to have more clear procedures, enforceable procedure to actually recover the financial damage. In the respect of enforcing the EU regulation on, we have a new law from February 2021, which established a support structure to implement the decision and enhance cooperation as regarding public prosecutor office. With these remarks, I'm closing our presentation, and I'm thanking for your attention. Once again, sorry for the mix-up of things in the beginning. Thank you very much.
Thank you very much, Christian. And First, I'd like to ask, has anybody any question? Has somebody any question? Úgy látom, hogy nem érkezett be a chatben kérdés, és még egyszer elnézést a technikai problémáért itt a fordítás kapcsán, és akkor utána elvezünk át Románia után Lengyelországba. A következő előadónk asszisztent professzor dr. Beáta Baran, a Krakói Jagellói Egyetemtől, a belső-külső büntető és szabálysértési nyomozás sajátosságairól fog beszélni, illetőleg az egyes eljárások közötti átjárhatóság problémájáról a lengyel jogban. Akkor kérném szépen a Beáta Baran azt mondja, hogy tartsa meg előadását. Please, Beáta Baran, keep your lecture.
Thank you very much. Thank you very much to the organizing committee, to the whole member of it. Thank you very much, distinguished speakers, for the predecessors' speeches. And let me present the topic of specialities of internal, external, criminal and infringement investigations, interoperability between these procedures in Poland. I hope the slides are visible and you hear me well. Let me present the presentation, which will cover such aspects as, firstly, the delimitation of the types of different proceedings, both internal and external, criminal and non-criminal ones. Then the characteristic of the presented proceedings and the interoperability of the discussed proceedings accordingly to the Polish legal system. The speech will be an attempt to show them in a context of protection of the financial interests of the European Union. And the first step for the analysis is to present the delimitation of types of proceedings, which can be described as representative and investigation, repressive and investigation proceedings. All of them can and are used also for combating frauds, money laundering, or other illegal activities which can affect the financial interests of the EU or the public funds. And each of them has a different aim and is conducted by different authorities, different bodies. What they have in common is their subject, conduct which is an act or omission in violation of the universally applicable law or internal regulations of the organization. And to my mind, it is possible to distinguish three categories of proceedings in the Polish legal system which are related to the protection of the financial interests of the European Union. The first category is are proceedings connected with criminal liability or criminal responsibility. Here there are four main types of proceedings which are based on the universally applicable law, and I present them briefly today. Let me enumerate them. So here we have common criminal procedure, then misdemeanor cases proceedings, fiscal penal proceedings, and collective entities criminal liability proceedings. We can call all of them external proceedings as they are not bound with any private law entity in terms of their conduct, and they are led by the law enforcement authorities, what means mainly the public prosecutor office and police. The second category, which I can enumerate it here, is there are proceedings connected with repressive responsibility, but not a criminal one. And they are also based on the universally applicable law. They usually are internal proceedings what means that they are led by bodies appointed by an employer. And as an example, here are disciplinary proceedings against officers of police formations, like, for example, border guard or police. And then there's the third category. The third category is internal proceedings, which are in principle not connected with any universally applicable law responsibility. They are usually based on the internal norms of an organization and are led by bodies appointed by an employer. What can be put here as an example is whistleblowing internal proceedings, which are included in anti-money laundering regulations. Let me focus on the first group of proceedings, the one which can be described as criminal proceedings. What is a common factor for all four types of proceedings I present in a minute is criminal responsibility, which is individual in the Polish legal system. Each of the presented proceedings is a kind of tool to combat crimes that can affect the EU financial system, and each of them is focused on slightly different aspects. The group consists, as I mentioned before, 4 different paths of claiming criminal responsibility. It means common criminal proceedings, misdemeanor cases proceedings, fiscal penal proceedings, and collective entities criminal liability proceedings. The first type is the criminal proceedings, which consist of common criminal proceedings before common criminal courts and before the Tribunal of State. It is generally regulated by the Criminal Proceedings Code. And as the aim of these proceedings is to achieve a state of substantive justice and appropriate criminal reaction. The latter means who is guilty of an offense should bear the responsibility for it just and only as he or she deserves under the criminal law. Its essence, therefore, is not to punish the innocent and punish the guilty one. The process should also aim at the proceedings should also aim at specifying the norm of substantive criminal law. In other words, changing an abstract legal norm into a concrete norm aimed at a specific human activity. How can it resonate with the EU financial interests? Firstly, the common criminal proceedings are the most frequent type of proceedings connected with criminal liability. This form of proceedings generally is initiated and or prosecuted ex officio, so by the public prosecutor's office or by police. They are also decided by the common criminal courts. And these proceedings are orientated for the prosecution of such crimes as, for example, corruption, money laundering, frustrating or obstructing a public tender. The first one, corruption, might take place during the EU funds distribution and seems to be one of those that can actualize, for example, during the EU Reconstruction Fund distribution. The other criminal proceedings are the special ones. It is before the Tribunal of State. The Tribunal of State is a special kind of court which jurisdictions cover violations of the Constitution or of a statute act of Parliament committed by and within the office or within its scope by the President, the Prime Minister, members of the Council of Ministers, so the government, and others who are constitutionally accountable to the Tribunal of States. The manner of proceeding is not often used. However, it might be a tool to fight offenses committed at the highest level of state power, especially those connected with major corruption or fraud cases that can be directly bounded with the EU financial interests. Another category I wanted to mention today is misdemeanor case proceedings. It is regulated by the Misdemeanor Proceedings Code. Misdemeanors include the smallest prohibited acts, usually with a low degree of harmfulness, and at the same time subject to lower sanctions. Misdemeanors may not be the most significant group of infringements associated with the EU financial interest, but still, they can indirectly affect those interests, especially in the event of a large number of smaller cases, which create an effect of scale. For example, misdemeanors against property or misdemeanors which can help to commit other prohibited acts like more serious crime, for example, such as producing seals or signs of a state or local government without proper order. Pointing the key differences between the criminal proceedings and the misdemeanor proceedings, the following issues should be mentioned here. Firstly, lack of preventive measures. Then, simplifications resulting from procedural economy. Exempli gratia, continuation of hearing despite a change in the composition of the court. Different poor evidentiary proceedings should be also pointed out here. Moreover, only exceptional participation of the public prosecutor in such cases can be brought to the light. And finally, a different catalog of negative prerequisites for the proceedings. The next type of proceedings, which I want to underline today, is the fiscal penal proceedings stated by the Fiscal Penal Code. This one can be described as one of the most appropriate to combat crimes against the EU financial interests. As an example, can serve one of the types of prohibited acts indicated in the Fiscal Penal Code, which states that whoever exposes public finances to depletion through undue payment, collection, or use a subsidy in a manner inconsistent with its intent, purpose, may be sanctioned. Also, different kinds of tax offenses and tax evasions are covered by the code. What should be underlined here is also the fact that the purpose of fiscal penal proceedings is defined by the legislator, its enforcement and compensation. What is worth underlying, penal fiscal law, since the adoption of the first Polish Penal Fiscal Act in 1926, showed differences from the general substantive criminal law and criminal proceedings. It clearly determines the appropriate differences from common criminal proceedings through inter alia distinctive and autonomous legal institutions, like, for example, the institution of voluntary accepting the responsibility. What I found also important is the fact that the authorities conducting the proceedings are different. These authorities include financial authorities, such as the head of the tax office, fiscal control inspector, head of the customs office, and non-financial authorities, such as border guard, police, military police, and in cases of tax offenses, also the Internal Security Agency and the Anti-Corruption Bureau. And coming to the last type of proceedings, which was enumerated, was a collective entity's criminal liability proceeding based on the Act of Parliament dedicated to that issue. It should be noted here that this way of proceedings can also be used against offences affecting the financial interests of the EU. The regulation is devoted to cases in which a collective entity shall be held liable for an offence involving the conduct of an individual if the collective entity benefited or could have benefited from the conduct, even non-financially. Such circumstances may materialize, especially in the case of unlawful shared European funds or bid rigging. In the Polish legal system, the criminal liability of individuals is understood classically as the liability of natural persons. So, the criminal liability of collective entities does not have a long tradition in the Polish legal system. It has been in force in Polish law for about 10 years. And nevertheless, it can definitely be useful when having in mind such unlawful acts like those connected with frauds and money laundering issues. The Polish Act adopted a cascade model of liability of a collective entity depends on the finding that a crime or fiscal offense has been committed by a natural person functionally related to the entity. Only after the closing of criminal or penal fiscal proceedings in the case of a person functionally related to a collective entity, upon a motion submitted by a prosecutor, a proceeding on the liability of the collective entity is initiated. Such shaping of the model of liability has led to its little application in practice, despite the importance of goals and hopes for new possibilities of combating economic and organized crime, which can affect also the public finances as well as the EU financial interests, like, for example, when dealing with tenders regarding the project sponsored or co-funded by the EU subsidies. Let's move to the next category of proceedings, which I mentioned at the very beginning. Proceedings connected with repressive responsibility, but not a criminal one. Here, disciplinary proceedings should be pointed out. The essence of disciplinary relations are acts of authority in which the public entity exercising disciplinary power imperatively determines the professional status of the accused person. Disciplinary law is a group of social relations related to the legal consequences of violating obligation resulting from belonging to entities performing public functions. This way of proceedings protects indirectly the EU financial interests, for example, in cases of unlawful spending of EU funds, which were dedicated to the purchase of equipment for border guards or police, and it's also a mechanism for combating crimes related to unlawful disposition of property, which was founded from the EU subsidies. Disciplinary liability is inherently related to public law, both at the substantive and procedural levels. Disciplinary law, including procedural law, should be treated as a branch of the law of autonomous nature, also in relation to criminal law, as the latter one does not cover disciplinary proceedings, as criminal proceedings only deal with issues related to criminal liability, which disciplinary liability is not a kind of. What is worth underlining, disciplinary proceedings is an internal one, but it is also connected with the public law responsibility. The general feature of disciplinary proceedings is their internal nature with a given organizational structure, police formation, and civil servants applicable. it does not change the fact that the decision ending the proceedings may be subject to judicial review. And last but not least, the third category of proceedings are internal proceedings, which are not connected with any universally applicable law responsibility. In my opinion, this category includes whistleblowing internal investigations. Also, the whistleblowing internal investigations are quite sparingly regulated. What should I point out here are two types of whistleblowing system in Poland, mandatory and optional one. The first one is present in Polish law only by sector. Generally, the banking and finance services sector, civil aviation sector, institutions exposed to money laundering, and some entities of the mining sector are obliged to implement it. For the scope of the presentation, the most relevant regulations are those related to money laundering issues, especially due to cases when the EU funds might be involved. The universally applicable law regulations provide an outline of the mandatory whistleblowing system, but the exact way of proceedings is regulated in the internal employer's policies or procedures. And what should be underlined here is an essential part of whistleblowing reporting system, which is an internal investigation led by a person appointed by a given employer. The internal proceedings is governed mostly by the internal regulations of the given entity. And when analyzing the institution of whistleblowing, it should be underlined that sanctions for hindering a whistleblower or retaliatory actions foreseen in the Polish legal system are differentiated and non-consistent. The newly adopted EU directive on the protection of whistleblowers is an opportunity to implement a coherent system of internal investigations in reaction for irregularities or wrongdoings. And what should be stated here is the issue of interoperability between proceedings I presented. There are several models possible in this sphere. Let me briefly present them. The first one is that the criminal and criminal-related liability proceedings and disciplinary proceedings, as well as internal proceedings, can be led parallelly. The aims and way of conducting them, as well as authorities, bodies conducting the proceedings are different. All those proceedings can be defined as directed at the question of whether an unlawful act or omission has occurred. Criminal and disciplinary proceedings can be described as punitive ones. Both of them are related to kind of punishment. And what is more, there is another variant possible when the first stage is the internal proceedings, and due to its result, there is a criminal proceeding initiated. For example, after a whistleblower report or fraud or money laundering case in a financial company like an investment fund. And finally, the third possibility that due to the criminal investigation, a private sector entity decides to establish an internal investigation or audit to check whether the given case is not affecting the one in other dimensions than the case conducted before the public prosecutor's office. So each of the presented variants is possible to realize. Let me come to the conclusion of my presentation. Primary, I should indicate that the outline I presented today has a general theoretical approach. And just to sum up, it is worth pointing out that there are different types of proceedings that can serve as a legal tool to protect the financial interests of the EU. They cover both criminal liability and non-criminal liability ones. In the Polish legal system, we can find both external and internal proceedings which can interfere in different dimensions. Aims of the given proceedings are not totally identical, but what is a common factor for them, all of them, is that there are some universal rules of proceedings which can govern them. But that's a problem for another presentation. Thank you very much. And sorry for the delay.
Thank you very much, Beata. And Szeretném kérdezni, van-e kérdés? Esetleg a chat ablakban szeretne még valaki feltenni, mert úgy látom, jelenleg nincsen kérdés. Have you got any question to the chat window? No, I don't see. Jó, és akkor ezek után folytassuk tovább a délutáni 4-es szekciót a Róma Egyetemnek az előadójával, Associate Professor Vincenzo Carbonéval, aki a büntetőjogi bizonyítékok az adóeljárásban címmel fog előadást tartani, az illegálisan megszerzett bűnügyi bizonyítékok jogszerű felhasználása Olaszországban. És akkor amennyiben itt van docens úr, akkor kérnem szépen az előadás megtartására. Egyelőre én még nem látom a Vincenzo Carbonét.
Can you hear me?
Okay, yes.
Oh, okay.
Thank you very much. Yes.
Very good, very good.
So please keep your lecture.
Thank you so much. I'm so happy to be here. I'm so sorry if I'm wearing the mask, but honestly, I'm getting vaccinated finally, and I'm in the hospital now waiting for my turn. So I hope that I will have enough time to do my lecture, but I'm more than sure that I can. So I will try to share my screen and wait a second. Very good. I think that you can see me. So thank you again for the invitation. For me, it's a real pleasure to be here. I'm so sorry that today I can meet you only with the digital instrument, and I really hope that next time we can meet again all together, like in the past. Let's see and let's talk about penal evidence in the tax process. I want to talk about this specific subject because in Italy we are in the last year adopting a strange approach, let me say, and I want to talk with you about this. So before I want to make a short introduction about the dual track system, a system that we are adopted in Italy. And it must be noticed that Italy adopts this kind of system to enforcement to deal with the tax offenses. Some offenses are administrative offenses, penalized through administrative law and the sanction therein. Other are criminal offenses. Those are penalized and or punished through criminal sanction. So in Italy, we have two autonomous sanction systems. This implies that in accordance with Article 20 of the legislative decree number 74 of the 2000, the penal judgment does not affect the tax trial, and the two proceedings run in parallel. In accordance with Article 479 of the Criminal Procedure Code, the criminal trial cannot be suspended pending the definition of the tax law. This system, as you can understand, can create some practical problems because, in other words, sometimes we punish the same conduct with administrative and criminal sanction. The doctrine has long highlighted the critical points of this dual track sanction system, especially with respect to the double jeopardy principle. But the Supreme Court, with the decision number 4439 of this year, but this is one of the last because we have several decisions in this sense, ruled that in case of tax crime, there is no nebis in idem. So the double track system is justified by the importance of national financial interest. Administrative procedure is aimed at recovering unpaid taxes, and criminal procedure is aimed at preventing and prosecuting tax offenses. So after this short presentation about the dual track system, let's see the evidence in the tax litigation. So Italian tax litigation is based on a civil law system and therefore solely on written sources. Generally, the decision in tax litigation is based only on the documentation provided for by the parties. Consequently, written testimony is not allowed. Third-party written statement, as well as information collected from third-party, can be used to corroborate the party's position. So they are considered like indirect evidence. And such indirect evidence can be used in judicial decision so long as they are not the sole base for the decision. The hearing is generally private in our system without parties attending, but legislative decree number 546 of the 1992 provides the right to request a public hearing up to 10 days before the scheduled hearing, in which the parties can explain their defenses to the tax court. If the party failed to attend, the litigation still takes place. Each party is entitled to file before the tax court any document considered useful for the case. There are no specific disclosure obligation under the Italian tax law. The judges have the right to ask to the parties for any additional documentation they consider useful to solve the case. The tax judge may request access to inspections, data, information, technical reports for public administration advice. In both in civil and criminal tax litigation, the burden of proof rests with the public authority. Let's see now the criminal proceeding. So a proceeding that is totally different about the previous proceeding, the tax proceeding. So evidence have been one of the most issues which the reform of Italian criminal justice system has taught with more effectiveness. It is worth noting that the code dedicates an entire book on evidences, the third book, which represents an actual microsystem, we can say. The book number 3 is divided in 3 titles, respectively dealing with the general principle, the single means of evidence, and the means of obtaining evidence. With reference to the first title, I mean, in relation with the principle, it is not mentioning that the code entrusts the parties with evidentiary power in all the stage of the fact-finding process. With regard with the search of the sources of evidence, the Italian system recognizes to the public and private parties wide investigative powers. With regard to the phase of admission of evidence, the Article 190 of our code states that evidence shall be admitted upon request of the party. The judge shall decide without delay by issuing an order excluding any evidence that is not allowed by law. Public prosecutor and judicial police, in the context of their respective duties, of course, carry out the investigation deemed necessary for the determination inherent in exercise of the criminal action. In accordance with the provision of the Article 329 of our Criminal Procedural Code, preliminary investigation documentation are kept under secret until the suspect can become aware of it, and in any case no later than the closure of the preliminary investigation. In order to create, and this is important, a solid barrier between investigation and trial, the Italian code established a double dossier system. On conclusion of the preliminary hearing with the committal to trial, 2 dossiers are created. In one hand, the trial dossier is formed, which contain only the documentation that are strictly provided by the code, and it is mainly evidence that is in ab origin impossible to reproduce in the court, like, for example, interception of communication or crime science analysis and so on. On the other hand, the investigative dossier is created, which contain all the documents referring to action carried out during the preliminary phase that are not filed in the first dossier. The judge does not have access to the investigative dossier, and the parties cannot take the initiative of reading at the trial any prior statements or other investigative records included in this dossier. The evidence in general taken during the trial, but also in the previous phase, must be lawful gathered. And this is an important principle, of course, and is a principle that is stated in a specific article in our code. I mean, the article 191 that established that evidence gathered in violence of the prohibitions set by law shall not be used. This is one, as I said, one of the most important article, according to me, and is also one of the most important innovation of this Italian evidentiary system, which aim at guaranteeing the principle of legality in evidence gathering. But, and I put this question, but can we use this kind of evidence that is not legal, let me say, because they don't respect the criminal code, the criminal procedure code, can be used in another trial, in another context, let me say, and that this is something particular, let me say. Why? Because in Italy, honestly, we can use this illegitimately, let me say, criminal evidence, and where we can use in the tax litigation. The court, with the decision 32,185 of the 2019, and also with another ordinance of the last year, but we have also in this case a lot of sentences, a lot of decision in this sense, confirm the usability of the evidence assumed in the context of criminal proceedings, also in the parallel tax proceeding, pointing out that this will not assume in the tax context equal probative value, but only circumstantial forces. At the same time, and this is particular, let me say, but I would like to use another word, they also go so far as to sustain the equal usability of the evidence that are illegally assumed, given the autonomy of the two proceedings. So, in other words, tax litigations in Italy may also arise from illegal evidence. The intent of the Supreme jurisprudence is not to waste investigative effort and cost. And according to them, this can be possible because, as we said, we have two autonomous systems, the dual track system that we mentioned at the beginning, and also because in the tax system, we don't have a specific article like the 191 that we mentioned a few minutes ago that consider not useful the evidence that are against the law. So this approach, in my opinion, runs counter to the taxpayer rights, fundamental rights, and also is against the constitutional rights. So I don't agree. the jurisprudence of the last years. And honestly, I'm not the only one in this state that don't consider available this kind of approach. But this is, so we hope that in the future, probably the Supreme Court will change idea and we will see the evolution of the jurisprudence in Italy. At the moment, this is the situation. So to protect the financial interest, especially the national financial interest, we adopt particular, or we interpreted in a particular way the law. And this is what happened in Italy. I don't want to take the floor for a long time. I'm so happy, as I told you, that I had the opportunity, even the trouble of the vaccination of the day, to share with you this information. And what can I say? Thanks for your attention. If you have any question, I'm at your disposal.
Thank you very much, Professor. And szeretném kérdezni, hogy van-e valakinek Vincenzo Carbonéhez kérdése a délután folyamán? Have anybody any question to Associate Professor Dr. Vincenzo Carbone? Úgy látom, hogy senkinek nem érkezett be a chat-ablakba kérdés. I haven't seen any question in the chat box, in the chat window. Akkor így köszönöm szépen Vincenzo professzornak az előadását. Thank you very much for your nice lecture, and I wish you bettering in the hospital. I hope your recovering will be soon.
Yeah, me too. Thank you.
Köszönjük szépen. És akkor tulajdonképpen most a 4. szekciónak a végéhez értünk. Egy rövid összefoglalást szeretnék csak adni a szekciónak a előadásairól. Tulajdonképpen azt a komplex jellegű előadás sorozatot, amit délelőtt elkezdtünk, a délután folyamán folytattuk, amit korábban professzor Róterika asszony is vázolt, hogy egyes nemzeti jogokban vizsgáltuk meg a OLAF és a tevékenységét. Ebben a 4. szekcióban Románia, Lengyelország és Olaszország volt soros, és akkor lassan a mai napnak a vége felé közeledve átadnám a szót Farkas Ákos professzor úrnak, aki elkezdte az 5. szekciót. Egyben ugye tulajdonképpen a konferencia eredmények összegzése is megtörténne.
Hát, tisztelt kollégák, hölgyeim és uraim! Lassan itt egy hosszú nap végére érünk, de azt hiszem, hogy a nap hosszúságát ellensúlyozta az a sok érdekes előadás, ami itt elhangzott a különböző témákban, amelyek mind a nyomozás körül forogtak, és sok információt kaptunk, amit most összefoglalunk, és az összefoglalóra felkérem Frank Meyer professzort Zürichből, már bekapcsolódott, úgyhogy please, the floor is yours.
Yes, thank you very much, Professor Farkas, for giving me the opportunity to summarize the outcomes of today's conference. I have to admit that you've given me an almost impossible task. It has indeed been a very, very long day with a series of very rich and highly interesting presentations. And I will do my best to summarize them and perhaps also to put them into the context of the overall design of this project. I have to admit, of course, that to do justice to all the presentation, it would have taken at least a day of preparation. So please forgive me if I do not manage to be too specific with respect to your respective presentation. I've written down a lot of notes over the day. And here is my summary, or at least my takeaway from this conference, which I participated in with great intellectual joy. And I have to admit that I've really learned a lot throughout the day. But I wish to start with praising the organizers in addition to the speakers with respect to the overall design of the project. I think it is indeed the right moment to start a project that deals with the most relevant questions of external, internal, and criminal investigations in the context of irregularities in the administration, the dispersal of EU financial interests, bearing in mind that the EPPO will become operational over the summer. The first cases seem to be already in the pipeline, and I think in that regard it is high time to address these questions. And I also think that the project has exactly the right focus, because it addresses two general shortcomings in international research in this area that have at least been on my mind as well for quite some time. One first shortcoming is the level of enforcement. We have talked quite a bit about substantive criminal law. We have talked about quite a bit about abstract principles, but at the political and also at the academic level, very little time is invested with respect to the actual enforcement of laws that have been induced or are related at least to union law. And this is a very important task. And it's also very important that I noticed how many participants you had throughout the day to reach out to practitioners, because it is them who have to apply the law and have to make the laws, the instruments work. And in that sense, in that regard, I noted with a lot of interest that you have also included training sessions in the overall scope of your project, which I think is very important, because everything that we discuss here, all our smart ideas that we probably exchange with each other, will have no bearing in reality if we do not reach out to prosecutors and judges and police investigators to actually convey our ideas to them and give them handy tools to actually implement the law. And secondly, what also is, in my view, a shortcoming at both the political and the academic level is the focus on the process, the legal process itself. I guess it was you, Professor Farkas, who started with that we need to think in procedural terms when we talk about or think about the determination of criminal liability. And I guess the project just wants to do that. And it is in that sense very important that the project is not trial focused, as many works in criminal procedure are these days. I guess we've seen throughout the day how complex new structures have emerged, not only in areas that have to do something with EU law, but generally in economic affairs. We see the emergence of a very complex procedural structures that intertwine administrative proceedings, internal investigations, and ordinary criminal prosecutions. And in that sense, it is very important, I think, both from a perspective of effective enforcement, but also from the perspective of rights, procedural principles, and structures, that we try to understand this complexity, and that we understand the criminal process as a multi-phase, multi-stage mixture of various proceedings, and nothing that is unilaterally focused on a criminal trial and then culminates in a criminal trial. And I guess the project does that in a very, very apt way. However, as we've seen, tackling this complexity brings a lot of challenges. The presentations have shown, of course, the importance of procedural law for the determination of a criminal liability, but it has also exposed a rich variety of procedural models, procedural instruments, a high diversity across jurisdictions, if not a disparity across jurisdictions, which might actually hamper the effective enforcement of EU law. What I've taken away is that there seem to be some international trends. We see a movement towards certain investigative and sanctioning tools. Just to summarize it a little bit, we have talked about the importance of internal investigations. We have talked about the increasing importance of settlements. We've heard much about the growing relevance of financial investigations and confiscations. I just mentioned the presentations here of Professor Spolt, Mr. Sackreuter, Dannecker, Kehrt, and Sawyer. They all have addressed these issues from the perspective of their respective jurisdiction. So there seems to be a certain trend that there is a sort of shared toolbox that is being used here in complex economic crime settings. The second trend that we see is the growth and increasing interoperability of multi-track proceedings. That became particularly clear over the course of the final presentations by Professors Kustan, Baran, and Mr. Carbone, which all dealt with these highly intricate problem of parallel administrative, internal, tax, and criminal investigations. And somehow this complexity needs to be resolved, or at least be taken into account when it comes to devising new structural principles or procedural principles for their application. I've also noted with great interest with respect to both trends that there seems to be a lot of discretion when it comes to when certain procedures are being triggered, how the various tracks of multi-stage and multi-phase proceedings interact. There sometimes seems to be just soft law, which governs the actual administration of these proceedings. And most interestingly, something that came out during the presentations of Ms. Siklos, Professor Sawyer, Mr. Dannecker, and also Gerson Trüg, that very often how these instruments are being used and perceived seems to be, to a large degree, depend also on national traditions and national cultures. And it also seems to be contingent on the size of the respective economies of a country. So apparently it plays a role whether you perceive yourself as an international powerhouse and the first big economy of the European Union, or rather a small middle-sized country. Of course, we could now say, fine, we can all go about our own business, and everyone chooses the way that he or she deems best suited for a national situation or a national legal situation. But that is probably not the right way forward, because we would lose two dimensions if we did that. The first one is obviously something that also many of you have addressed, and that is the position of the defendant. The defendant is somewhat lost here. And that was also the reason why I asked Gerson Trüg this morning to what extent the transnational dimension has an impact on his work. but he said that his procedural models would basically remain the same. There would just be more complexity. This afternoon, we also heard that there are some problems here that, in addition to an increased complexity here, somehow needs to be addressed because it is produced by these new trends and this increase of multi-track proceedings. And what particularly stuck in my mind was, first of all, the problem of transfer of the evidence. I guess Geert Dannecker has already addressed this this morning. If I take evidence in an administrative proceeding or in an internal investigation, am I allowed then to transfer it to the criminal stage? And if so, under what conditions? Secondly, something that Professor Kert addressed, how do I deal with these huge amounts of data, this bulk intelligence that is something that has become something that happens quite often in white-collar investigations? How do I access this kind of information, in particular if it's not located in the same jurisdiction, but dispersed across many jurisdictions? Another question or problem that came up in that regard is, of course, the problem of the presumption of innocence, and how do duties to cooperate in administrative proceedings affect the presumption of innocence, or also the privilege against self-incrimination? What are the mechanisms in place here in order to make sure that a legal person or an individual person which is the subject of administrative investigations, or which has to participate in an internal investigation, is not irretrievably prejudiced with respect to criminal proceedings that might start later on? And of course, most importantly, something that was addressed by Professor Kustan and also by Professor Carbone, the nede bis in idem principle. What kind of decisions in these multi-phase, multi-track proceedings would actually trigger ne bis in idem? But that is something that is not entirely new. I guess many of us have already done some research in this area, or have discussed this problem with colleagues before. What I would like to focus on in the remainder of my time is the EU dimension, something that was brought up in his introduction by Professor Farkas, but also early on by Gerhard Dannecker. I think, and that is my own position here, that the diversity, the variety that we have seen here is to a certain degree, or let me put a question mark to it, is this variety and diversity sustainable in the EU dimension? If we think about the proceedings with respect to achieving its ultimate goal, effective enforcement of EU law, and in the particular context of your project, the effective protection of EU financial interests. So we have to start contemplating to what extent do we really have to what extent this EU dimension of investigations bears actually on the enforcement of the law, and it may do so in many respects. I will just pick on two aspects that have been mentioned today. The first one is the constitutional legal framework, if you wish. As soon as EU law is applied, or as soon as a prosecutor becomes active in an area that is to a certain degree dominated by EU law, think about the Akerberg-Franson case and the Tarico decision, then the Charter of Fundamental Rights applies by virtue of Article 51 of the Charter of Fundamental Rights. So the constitutional framework that needs to be addressed here and that needs to be implemented somehow when we use all these new instruments and multi-phase proceedings in the context of the enforcement of EU interests this constitutional legal framework is the Charter of Fundamental Rights. And it goes way beyond the European Convention on Human Rights. That is what we know as a way of abstract general knowledge. But what we have problems with is actually substantiating the Charter of Fundamental Rights, the specific articles that deal with these kind of proceedings, in a way to give them meaning and give them critical bite in the context of these new proceedings. And that will be a challenge in the future. And I also assume the subject of the next conference of your project, or at least partly. Secondly, something that Professor Dannecker and Professor Mears have both brought up, that is the issue of effectiveness. If I become active in the area of union law, if my main duty is the enforcement of EU law, all the EU enforcement principle also apply. In particular, the principle of effectiveness based on the duty of loyal cooperation. And one aspect was earlier mentioned this morning, the effectiveness or the claim to effectiveness of EU law might limit the possibility to rely on certain national procedural rules, certain national standards, in particular also national safeguards and national constitutional law. And Professor Mears just added one dimension in his presentation, the idea of primacy, which also rests on the idea of loyal cooperation to a certain degree, might also lead to the fact that national laws must be disapplied, which might be somewhat shocking for national lawyers, but that is a standard operating procedure in many other areas of EU law. However, as I'm a criminal lawyer, I am not willing to give cherished criminal law principles away too quickly, but I think it is here where we need to start thinking. And bearing in mind what kind of variety we've heard about over the course of this day, it became clear to me how enormous the challenge is to find some common ground here, or at least to find a way forward with respect to the question, how much common ground do we actually have to find? To what extent is a variety okay? I guess no one wants uniformity. I guess Professor Horvath said it in her introduction, that criminal law is for most of us still a national affair, rooted in national principles and national culture, national tradition. And Article 4, Paragraph 3 of the Treaty of European Union pays respect to national identity and tradition. And if we want to make sense of this obligation that our processes, our instruments that we have discussed today in the context of the effective protection of EU financial interests, actually achieve the goal of effectiveness and at the same time comply with EU fundamental rights, that does not necessarily mean that we need a one-size-fits-all approach. But the interesting challenge, interesting question for which I have honestly no solution at the disposal here right now, will be for the future to find a common framework that allows us to answer these questions. And the common framework will consist of a couple of components, perhaps 4 that I will briefly go through if you allow me this time. First of all, in that sense, the presentations make me quite hopeful here. I go back to what Professor Farkas said in his introduction. We need some sort of common grammar. We've sensed, I guess, all who've listened carefully to the presentations, that we all have to deal with similar problems. So normatively and structurally, we have the same focus on the problem, and that is a good starting point. The second step will then be, do we find common concepts that allow us to speak the same language as lawyers at the very least? And this builds a bridge to what Gerd Dannecker said this morning, we also need a new transnational principles. Perhaps the transnational dimension could have been teased out a bit more, perhaps it's something to do in previous conferences. One of the key challenges is obviously that we do not only have these multi-stage, multi-phase procedures within one jurisdiction, they also overlap trans-jurisdictionally. National countries overlap and all under the same umbrella of EU law. And in that regard, we need to think procedural protections in a transnational dimension. And luckily, unlike the European Convention on Human Rights, the Charter of Fundamental Rights actually recognizes this dimension. So we have something to build on. But with respect to how we go about it, in particular, coming back to the problem of effectiveness, we have, that would be the third challenge, I think, address the underlying fundamental questions that have not been answered so far. We know that the enforcement has to be effective. We know, on the other hand, that we need to respect national traditions and structures, but we have not really talked about what this effectiveness actually means in the context of criminal prosecutions. Is this an abstract notion? Does it apply to the totality of cases? Is it a requirement for specific cases? Does EU effectiveness mean total legality, mandatory prosecution in all cases? What is the discretion here? What is the wiggle room that national prosecutors, national enforcers have in that regard? To what extent do we really need uniformity? How much diversity and traditional or national divergence is okay? It might be possible to achieve a certain policy goal, which is okay from the perspective of EU law, in totally different ways in different jurisdictions. And I guess there's not enough discretion and enough flexibility in EU constitutional law to allow for this flexibility. But I guess we have to discuss this somehow, and it is high time to discuss this because the EPPO will most definitely have to deal with these questions. And their guidelines and their directives will somehow have to propose solutions on how to deal with different procedural contexts and different procedural traditions. Fourth, in particular with respect also to procedural principles, but also with respect, and that is one of my key concerns, with respect to fundamental rights of those who are affected by transnational proceedings, in particular if they are multi-phased, multi-staged. I think we also need a change of perspective. If EU law is being enforced, if the national crimes that are being applied by prosecutors, by police investigators, or other administrative agencies, if these crimes are rooted in EU law, if they have an EU background in Articles 83, paragraph 1 or 2, then what we see here is actually a joint exercise of public authority. We see Hoheitsgewalt, public authority, exercised on behalf of the European Union. So it's not only the public authority of Hungary, of Romania, of Germany, of Austria. It is, if you don't say straight away, it's entirely EU public authority that is being exercised here. It is this joint authority. And this aspect of joint EU public authority also provides a new perspective on the situation of the defendant. It makes it possible to strengthen the position of the individual, to make sense of his fundamental rights in a new way, and in particular in this new transnational dimension, because it's not possible to simply say, you as a citizen, you're affected by prosecutions in Hungary, and the Hungarians deal with what happens in Hungary. And then you're also affected by administrative proceedings in Germany, and the Germans deal with that. And you might also be affected by financial investigations in Romania, and the Romanians deal with that. That is the wrong perspective. If all the various roads lead back to EU public authority, That means that we need new concepts of infringement for constitutional rights. We need to bear in mind the additive, the cumulative, the transnational impact of these investigations, and we have to specify the Charter of Fundamental Rights in that regard. Now the final question, who's in charge? Of course, it's our duty as academics to address these questions, but I would also suggest to further strengthen the idea of positive obligations in the Charter of Fundamental Rights. The duty to fulfill that rests on the EU legislative bodies. If they create these maze of proceedings, if they force national states to enforce EU interests and force them to apply EU law in an effective way, and create and demand all sorts of new instruments, they are also under an obligation to provide a reliable framework for that. And with a reliable framework, I not only mean the minimum requirements for approximation of laws at the national level, I mean a transnational model, at least something that is robust enough to come to terms with these challenges. And I think a good example in that regard, how this can work, is actually the German Verbandssanktionen Gesetz, which, again, due to the resistance of the Christian Democrats, will probably once again not be adopted. But I listened very carefully to what Mr. Sackreuter said, and also to the remarks of Gersan Trüg and Richard Sawyer. Here we see a legislator which understands that internal investigations are something new. It is something that has grown into a kind of quasi-procedural tool that interacts with other state instruments. It has become commonplace, at least in Germany, in high-stakes proceedings that involve high-level corporations. If I allow such structures to grow, I have a responsibility as a legislator to somehow coordinate that. What path I will take at the end of the day, which is probably the smartest way or the least smart way, that is something that we can, as academics, can debate, I guess, for long hours and over a series of conferences. But what I demand is that the legislator takes responsibility and actually acts and offers something. And I, in that sense, disagree with those who say, well, internal investigations are a matter of labor law and a matter of company law. That is not the case, because internal investigation have grown into something quasi-public. And the impact on criminal proceedings are so immense that they cannot be let unregulated. Now, there are many ways to regulate them, but it is important at least to do something. And we can take this, I guess, as one particular example, how solutions can be found at the international level. I see indeed a necessity to regulate here. Of course, I'm also concerned that the EU will produce serious blunder and over-regulate. But something similar can be said about the Verbandssanktionen Gesetz. It's probably not the smartest hour of the legislator, but nevertheless, it has offered a path forward. And this is what I hope for in the future. And this allows me to come back to my final words here. If the EU bodies are supposed to engage in such efforts, they need a profound understanding of what goes on the ground. And I guess the presentations of the kind that we heard here this afternoon and this morning provide us with the knowledge that we need in that regard. We have all become clear or presented in a very clear way that there are no easy solutions, that everything is very complex, intertwined, but that's reality. And if we want sober solutions and workable solutions in the future, we need a clear-cut and not starry-eyed view for the realities of criminal prosecutions. And you, the speakers who I congratulate on their presentations, have laid the foundations for that. So thank you very much that I was allowed to participate here and that I was allowed to share my conclusions and my summary with you. Thank you very much.
Elnézést, csak egy kis technikai probléma, de azon adódott, de azonnal megoldjuk. Legalábbis reméljük.
Igen. Jó, videó is stop, és miért stoppoltam én le?
Well, as long as you try to find a solution for the technical problems, I want to congratulate me, because it was my suggestion to ask Frank Meyer. And I think this was really a great conclusion, a summary. It was excellent. It was really excellent, and it shows that it is a good concept what we have, that we have these practitioners and that we have academics and we discuss these problems together. So thank you very much for that. Now the technical problem seems to be solved.
Jó. Hát akkor nagyon szépen köszönöm, hogy átvetted a szót erre a néhány percre. Először is meg szeretném köszönni Frank Meyer professzornak, hogy ilyen alaposan, strukturáltan és az előadásokat végigkövetve és tartalmát is visszaidézve összefoglalta mindazt, ami ma történt, és amit ma hallottunk. Ez az első konferencia, de még lesz 3 konferencia. Ősszel Heidelbergben találkozunk, feltehetően még mindig online, és a jövő évben pedig egy workshop és egy záró konferencia koronázza meg végül ezt a projektet. Én úgy gondolom, hogy valóban ez volt a kezdet, és számos olyan kérdés volt, amit még nem tudtunk kitárgyalni, de erre való ez a projekt, és erre való, hogy a későbbiek során még bővebben, még kidolgozottabban és alaposabban tárgyaljuk meg azt a problémát, ami a nyomozással, a nyomozáshoz kapcsolódó problémákkal, a joghatósággal, a nemzetközi bűnügyi együttműködéssel kapcsolatos. De ez egy nagyon jó kezdetnek bizonyult, és nagyon sokan érdeklődtek a téma iránt. És ha azt mondom, hogy reggel 257-en plusz még a szekcióvezetők és a panelisták számával bővítve, tehát majd 280-an kezdtük el ezt a munkát, és most, hogy közeledünk a befejezés felé, még mindig több mint 100-an itt ülnek a kamerák előtt, és online hallgatják a mondandónkat, akkor talán nem vagyok nagyképű, hogyha azt mondom, hogy olyan témával foglalkoztunk, amely sok szakembert vonz, sok szakember érdeklődését kelti fel, és ez talán biztatást ad nekünk ahhoz is, hogy a projekt végén végül egy olyan nyomtatásban is megjelenő anyagot tegyünk közzé, ami egyrészt érdeklődésre tart számot, másrészt pedig az oktatásban és a képzésben is felhasználhatunk, bővítve azt a perspektívát, azt a keretet, amit számunkra a büntetőjog, a bűnügyi együttműködés biztosít. Nem kívánom tovább szaporítani a szót, viszont szeretnék köszönetet mondani. Köszönetet mondani a szekcióvezetőknek és a panelistáknak a közreműködésért. Utánuk közvetlenül nagy köszönet a tolmácsoknak, és ilyenkor tapsvihar szokott kitörni, de én csupán személyesen közvetítem a jelenlévőknek az elégedettségét a tolmácsolással, és a teamnek, akik itt Miskolcon közreműködtek abban, hogy ez a konferencia simán és mindenki számára élvezhetően bonyolódjon le. Először a főtechnikusunknak mondanék köszönetet, Szilágyi Zsoltnak, aki karban és kézben tartotta magát a technikát, és külön a szervezőbizottság munkáját is megköszönöm. A projektvezető ugyan én vagyok, de aki a gyakorlati munka dandárját lebonyolította, az egy tím, Élén Jacsó Judit professzorral, Róth Erika professzorasszonnyal, Jánosi Andreával és Udvarhelyi Bencével, akiknek a munkáját, közreműködését egyrészt megköszönöm, másrészt pedig a köszönet mellett felhívom és emlékeztetem őket arra, hogy további feladatok is várnak ránk, és ezeket a feladatokat most már megadtuk a mintát, hasonló színvonalon szeretnénk végrehajtani. És utoljára, de nem utolsó sorban szeretnék köszönetet mondani a Miskolci Egyetem Gazdaságtudományi Karának, hogy lehetővé tette számunkra a Zoom rendszer kiterjedt, bővített használatát, amelynek eredményeképpen tudtuk a tolmácsokat is így bekapcsolni, hogy minden hallható, érthető és követhető legyen. Mindezeket a köszönő szavakat azzal szeretném zárni, hogy úgy érzem, hogy sikeres konferenciát bonyolítottunk le, és mindenki most már megérdemelten térhet nyugovóra úgy, hogy egy gondolatgazdag, informatív napon van túl. Köszönöm a figyelmüket, köszönöm a jelenlétüket, köszönöm a közreműködésüket, és viszontlátásra ezzel tudnék elköszönni, és szép estét, jó éjszakát kívánok Önöknek. Köszönöm szépen. És akkor mindenkit, aki érdeklődő volt, az maradjon érdeklődő, és mi pedig csak gyarapítani fogjuk mindazt, amit elhangzott, és következik Heidelberg, ahonnan ismételten jelentkezünk ősszel. Köszönöm szépen. Még egyszer. Aha. Aha.